we embark on a journey to trace the corridors of justice where the battle against corruption takes center stage and the pillars of righteousness stand tall. With that, I request our own Professor Dr. Jyoti Vishwanath ma'am, Professor University Law College and the program coordinator for this event to welcome the guests.
Good morning to everybody here. Respected Hon'ble Chairman, NGT State Level Committee, Karnataka, and former Lokayukta, former Judge, High Court of Karnataka, Shri T.M. Vijay Bhaskar sir, IAS retired, former Chief Secretary of Karnataka, and former Chairperson, Karnataka Administrative Reforms Commission, Chairperson, IIPA-KRB, respected Professor Dr. Jayakara S M, Vice-Chancellor, Bangalore University, Bangalore, respected Professor Dr. V. Sudesh, Principal and Chairman, University Law College and Department of Studies in Law, Bangalore University, Bangalore, Professor Dr. N. Dasharath, former Chairperson and Dean, Professor Jeevan Kumar sir, who is the Secretary of the IIPA, Bangalore, Professor Madhwaraj, Joint Secretary of IIPA, Bangalore, my dear colleagues, Professor Dr. N. Satish Gowda, Professor Dr. Chandrakanti, the other faculty, students, members of Academic Council, Syndicate, I welcome you all to the present program. Today, it's a proud privilege to stand in front of this August gathering as the program coordinator of this capacity building program. Today, we have assembled here to shift our focus for a while to a very important topic which touches and concerns the life of each one of us, and at the same time having a great impact on the society and the economy. The Honorable Prime Minister of India, Shri Narendra Modi ji, in his 76th Independence Day address had referred to two important challenges confronting our country, and they are corruption and nepotism. As per the Corruption Perception Index 2023, India has 40 index points with 85 rank, and for information of all, in this index scale, 0 is highly corrupt and 100 is very clean. So with such a poor ranking of our country, it can be vehemently said that we undoubtedly have a high level of dishonesty in the circles of power and position. Respected all, with the motive and intention of getting a analysis of the corruption scenario in the country. Subhash B. Adi, former Judge, High Court of Karnataka, NGT State, sir, to this program. I also take this opportunity to welcome Shri T.M. Vijay Bhaskar, IAS, former Chief Secretary of Karnataka, former Chairperson, Karnataka Administrative Reforms Commission, and present Chairperson of IIPA-KRB. I also take this opportunity to welcome our own beloved Honorable Vice-Chancellor, Dr. Jayakara S M, Vice-Chancellor, Bangalore University, Bangalore, to the program, sir. I welcome Professor Dr. V. Sudesh, our beloved principal, who has supported in this organization of this committee, or this program. Welcome to the program, sir. I also welcome Professor Jeevan Kumar sir, who is the Secretary of IIPA-KRB, to the program, and who has also co-coordinated the program with me. Thanks for all your support, sir. I welcome Professor Madhwaraj, Joint Secretary of IIPA-KRB, who has taken out time from his busy schedule to attend this program. Welcome to the program, sir. I welcome Professor Dr. N. Dasharath, the former Dean and Chairman of this department. Sir is always with us. Thank you very much, sir, for coming for the program. I welcome my own colleagues, Professor Dr. N. Satish Gowda, sir, and Professor Dr. Chandrakanti. Welcome to the program. And I also welcome all the other guest faculties, the students, members of academic council, syndicate, and teaching and non-teaching staff to this program. Welcome to all of you. I will welcome all of you with the Chanakya Niti Shloka 7.4. What Chanakya says is that one should be satisfied with one's wife, that is spouse, food and money. One should never be satisfied with one's study, chanting and charity. Thank you. Welcome to the program.
I request a round of applause to welcome the person who welcomed all of us, Professor Dr. Jyoti. Moving on to the next segment, we have the introductory remarks by Shri Vijay Bhaskar sir. Before moving on, before asking him to address the gathering, I will just introduce him briefly. Shri Vijay Bhaskar sir is from Bangalore, holding a master's in economics from the BITS Pilani, India, and an MBA in public sector from University of Birmingham, UK. He joined the Indian Administrative Service in Karnataka cadre in 1983 and served for 37 years in various capacities in the government of Karnataka and the government of India. In these 37 years, he worked in various capacities in district administration, education administration, rural development, and coordination in posts in Government of India and in Government of Karnataka. He retired in December 2020 after 2.5 years of service as Chief Secretary to the Government of Karnataka, which is the senior most official in the state administration and responsible for coordination and overseeing all the departments of the state government. Shri Vijay Bhaskar sir served as the Chairperson of the Karnataka Administrative Reforms Commission 2 from January 2021 to December 2023. The Commission submitted 6 successful reports to the Government of Karnataka under his leadership. He is the current Chairman of the Karnataka Regional Branch of the Indian Institute of Public Administration. A big round of applause to welcome him. Sir, over to you.
Thank you. Good morning to all of you. Once again, I welcome all of you to this program on behalf of IIPA, Karnataka Regional Branch. Justice Subhash Adi, Dr. Professor Jayakara, Professor V. Sudesh, Professor N. Dasharath, Dr. Jeevan Kumar, Professor Jyoti Venkat Vishwanath, Professor Madhwaraj, and dear faculty, students, ladies and gentlemen. Today, it is our pleasure on behalf of IIPA and the University Law College and of Bangalore University to organize this. We are thankful to Justice Adi who immediately accepted our invitation to come and address this program. We are thankful to University Law College and Bangalore University for arranging this program. Indian Institute of Public Administration was set up in 1954, and Pandit Jawaharlal Nehru, our first Prime Minister, was the chairman of IIPA for more than 10 years. The IIPA has different regional branches, of which Karnataka Regional Branch is one, and I am the chairman, and Professor Jeevan Kumar and Professor Madhwaraj are on the board, office bearers of the IIPA Regional Branch. So the IIPA acts, it tries to act as a bridge between academia and administrators, by taking up capacity building programs, by arranging lectures, by ensuring that the latest developments in academic research are available to administrators, and the latest programs, policies of administration are communicated to students and the faculty of university. So this cross-fertilization of ideas, which is very common in developed countries, is still to progress much in our country and in Karnataka. So we need to forge stronger links between academia and administration, and IIPA serves to fulfill this function. Now coming to the theme of today's lecture, which is legal regime on anti-corruption in India or anti-corruption in India. So all of us are affected by corruption, and those of us who have worked in government are also responsible for this in some respects. What we have to see is, of course, corruption is not a new phenomenon also. Professor Jyoti Venkatesh was referring to Kautilya, and those of you who are all aware of Arthashastra, it has a large number of provisions on dealing with corruption in public offices, by public servants, etc. So it's not a new phenomenon. What is required? This is a constant fight against corruption which has to take place. We also see that there is a strong correlation between the level of corruption and the level of literacy and the level of per capita incomes. How you can see that if you go to Transparency International, the state which is ranked the most or least corrupt is say Kerala, which also has the highest human development indicator, the best literacy. So how does literacy affect it? We are all aware. People who are illiterate are more prone to getting misled, by getting exploited. Similarly, it is correlated to per capita income. The richer the country, the less incentive there is for public servants to demand corruption or demand bribes, etc. So that is also there. If you look at Transparency International rankings again and correlate it with per capita income, you will find that the poorer countries are all ranked the most corrupt, whereas the richest countries are kind of the least corrupt. So there seems to be a correlation, which is we can all understand. So there are different types of corruption. Of course, petty corruption and grand corruption is there. Petty corruption is what we all encounter in our daily lives when we have to get a driving license. You have to pay something to someone to get the driving license. If you want to get some building license, you have to pay something. So this is petty corruption. Grand corruption occurs at a higher level. It is mostly linked to expenses on elections, etc. So that is another type of corruption. Now, in the Administrative Reforms Commission, we have tried to address this by reducing the scope for corruption, by reducing the incentives for corruption. Some of the recommendations that we have made, I would like to share with you. One, reducing discretionary power of officials. So, for instance, I can give you one example. In the Excise Act, if you are caught drinking in a public place, then you can be fined any amount between 500 rupees and 2000 rupees. So there is a discretion for the excise officer to either fine you 500, then of course he has discretion not to fine you at all, discretion to fine you either 500 or any amount up to 2000. So that discretionary power which officials have, by reducing it, we can reduce the scope for corruption. Procedures, by automating procedures, by imposing statutory time limits for providing services. We have the Sakala Citizen Services Act, under which statutory time limits are fixed. But this is not effective also because of various reasons which relate to monitoring, which relate to appeals, which relate to fines, low fines, and not imposing penalties. The second thing is use of technology can reduce corruption a lot. So by making services, for instance, you can say a railway reservation. Earlier you had to go to the railway station to book a ticket. Now, of course, none of you will remember this, but we all, on the stage, we remember all this. But now, all this is contactless, cashless, and paperless. So this making more and more government services contactless, paperless and cashless will also reduce the scope for corruption, which we have recommended in many of our reports. Transparency. The Right to Information Act is a great check against corruption, because there you can get information and you can also question people in authority. Decriminalization and compounding of offences. So the more provision there is for compounding, for instance, if you're going on without a helmet, driving a two-wheeler without a helmet, if there is a provision, if every time you have to go to court and appear in court, the scope for corruption increases, because then you will feel that, okay, rather than going 5 times to court and wasting 5 days, I can pay so much of bribe and get out of it. So, but there is a provision for compounding. So if you are asked to pay a fine of 500 rupees, you prefer to pay a fine of 500 rupees. So that also, if there is a procedure for on-the-spot fining, on-the-spot giving receipts, cashless payment, it reduces the scope for corruption. Because accountability we have, which Professor Adi will talk to us about, the 5 C's we call it: courts, committees, the Public Accounts Committee, Comptroller and Auditor General, Central Bureau of Investigation, Central Vigilance Committee. So these are the 5 C's which oversee the anti-corruption legal framework in our country. In the state, because the new institutions are Lokayuktha in Karnataka, which Karnataka was the first to have a Lokayuktha. Government of India has the Lokpal. So our Lokayuktha has, thanks to people like Justice Adi, we have it's got a very good reputation as being one of the most effective institutions among the Lokayuktas. So this is the framework. There's one issue that may not be in your knowledge, which we have addressed in our reports, is realistic amounts of office expenditure. So people in government offices, you may not know, though we all feel that they have to spend a lot of money from their own pocket, because government does not give them, which of course I am also partly responsible as a former officer in charge of the state, in the state administration. We do not give enough amount for office, for buying paper, for buying printers, for traveling expenditure, etc. So what they do is they tend to ask for money for this. So if you go to any office in BBMP and ask them, ಎಷ್ಟು ಪೇಪರ್ ಉಪಯೋಗ ಮಾಡ್ತೀರಿ, they will say reams and reams, printers, printing cartridges, hundreds of printing cartridges for printing, but they will say we don't get enough money for all this, we have to pay from our own pocket, and no one, because you will know that none of us would like to pay from our own pocket. So this also we have addressed in our reports by recommending that realistic amounts will be given for office expenditure, travelling expenditure allowances for everyone, right from say constables upwards, so that there is less, they have a less incentive, or there is a compulsion to ask for bribes. So these are some of the aspects that I would like to bring to your notice as an introduction to the subject. Now along with you, we look forward to the keynote address by Mr. Subhash, and I thank you for your patience in listening. Thank you very much.
Thank you, sir, for such an elucidative address. Now, before moving on to the keynote address, I'd like to introduce our chief guest, Hon'ble Justice Subhash B. Adi, sir. Justice Subhash B. Adi, sir, has served with more than experience of 20 years as a lawyer and has served as a former judge of the High Court of Karnataka. He was born on 10th of August 1951, and his education qualifications include a bachelor's in science along with a bachelor's in law. In 1978, Sir enrolled as an advocate and started working in the High Court of Karnataka. He has practiced in several branches including civil, criminal, constitutional law, taxation law, company law, labor service, and other ancillary matters. Furthermore, he has specialized in other subjects like local bodies and land reforms. He was appointed as an additional judge of the Karnataka High Court on January 6, 2006 and elevated as a permanent judge on March 1, 2007. He retired as a judge in 2013, after which he went on to become the Lokayuktha of the state. In 2018, Sir successfully served as Lokayuktha and retired from the office. Furthermore, he has also chaired a number of state-level committees and is currently the chairman of the state-level committee of the National Green Tribunal for the state of Karnataka. Welcome, sir, and with a big round of applause.
Most esteemed, respected TM Vijay Bhaskar, the former Chief Secretary and Chairperson for IIPA Karnataka Region, Dr. Jayakara, the Vice-Chancellor of Bangalore University, Professor Dr. Subhash, the Principal of Law College, Dr. Dasharath, Dr. Jyoti Vishwanath, students, leaders, professors, my dear students. Indeed, it is a great opportunity for me to address the excellent gathering in the midst of highly intellectual personalities on the dais. The subject chosen for the today's program, the legal regime on anti-corruption in India. The corruption is nothing new. It was there in the history, even in mythology you come across the corruption. For example, Kittur Channamma, a ruler of Kittur then, there were two persons, Malashetty, who were corrupted to defeat the war by the British. Now, it is not something new, not new. Corruption is not only affecting India, but worldwide. It is a common phenomenon for every country. World has enough for everyone's need, but it does not have enough to fulfill the needs of a greedy. If the state economy goes in the hands of wicked or greedy persons, then no amount of resource can save it from drowning. 62% estimated by the survey conducted by various institutions. Now 62% of the population has the first-hand information and experience of the corruption in a day-to-day life. Now in 1961, United Organization Convention Against the Corruption resolved solicitation or acceptance of by public servant directly or indirectly of an undue advantage shall fall within the ambit of the corruption. Now in the welcome address, Srimati Jyoti mentioned that India ranks 85 amongst the 200 countries and 40th from 0 to 100 corrupt countries. Now, what are the reasons why it's so happening? If you look at the total budget of the country or the state and look at the amount of corruption that goes on the other hand, it is estimated that the 50% of the GDP is in the corruption. Now, it's such a huge amount. How it goes and why it goes and what happens? Now, we'll take examples. Now, the political funding, which was a debate and which was a matter before the Supreme Court also. Now, India has got 8 recognized political parties and 3,000 registered unrecognized political parties. Now, these political parties are not the state or the public authority. And the reason that they are exempted from disclosing the source of their funding. Now, each of the, if you take the average, I don't want to mention the particular parties, but if you take the average, now more than 50% of the funding is from the unknown source. Now, the tax evasion is apparent because there is an exemption clause. Funding to the political party, they get the exemption. So, this is the area, this is the first part. Now, the other area, like bureaucracy, I'm sorry to mention, Vijay Bhaskar was one of the finest administrator, and I had an occasion to work with him, and a greatest support, he was a support to me in the Lokayuktha also. 43 to 45% of the bureaucrats estimated to be corrupt. And for example, when 2016, when 500,000 currencies were banned, do you know the gold purchase, which was estimated, it was increased from 20 to 30%, and the rate which was 31,000 and odd jumped up to 45,000 because of the high demand of gold to purchase because of the notebandi. Now, the black money in India is equal to the budget of the Indian budget. Now, such a heavy, if you look at, don't need to borrow any money, but if you curtail the corruption, it is more than enough for everybody's need. Now, we have several, just now 5 institutions. We have several institutions, several reforms, several administrative reforms also. But despite that, we are not able to come out of these clutches. Now, in 1997, being a law student, you must be familiar. 1997, the Supreme Court, in the judgment of Swatantra Singh versus State of Haryana, an observation was made: corruption corroding like cancerous lymph nodes, the vital veins of the body, political, social fabric of efficiency in the public service, and demoralization of the honest officers. The reputation being corrupt would gather thick and unchaseable clouds around the conduct of an officer and gain notoriety much faster than this book. This was the Supreme Court's observation. And in 2011, again the Supreme Court had an occasion to mention, even in 2023 also it was mentioned, these judgments were referred in 2023 also. Corruption by public servant has become gigantic problem. It has spread everywhere. No facet of public activity has been left unaffected by stink of corruption. So what is required is purity of administration. Now the administration reforms, the institutions are there. Purity of the administration needs free from corruption. Now coming to the the legal aspects. Now, again, fighting against the corruption. Fight against the corruption. We have the institutions, we have the laws. Now, who are the stakeholders? First is the administration, second is the legislation, third is the enforcing authority, then the legal system. The recent incident and one earlier incident also. Now the legislative authority is one of the wing of a constitution. Now this is a supreme body for the state and supreme body for the country, where the laws are made for the general public. Suppose if the corruption enters the supreme body, which has got a privilege, the privilege from all other things, and they said it happened, and the privilege committee was towards one of the parliament members. Now in 1998 also, the Supreme Court had an occasion to deal with JMM case, that is a P.V. Narasimha Rao. P.V. Narasimha was short of a vote in the no confidence motion. 265 was the requirement and 251 was the supporting. So there was a short of number of 14 votes. So he was to match the 14 votes. That is the JMM case. Now there was a charge and the matter went to Supreme Court. Now Supreme Court, while considering that matter, was to consider several other countries, the judgments and also the history of their parliament system. Way back in 1875, the Australian Supreme Court, then under the British rule, observed that attempt to bribe a member in order to influence his vote was criminal offense under the common law. Now you all know the legislators functioning within the premises of the parliament or the assembly, they have got the privilege. Now this privilege was claimed that even in respect of the voting in the parliament, this privilege was also claimed in respect of the legislative assembly. The question was whether they are immune to this type of acts. Day in, day out, I may mention it, maybe outside my scope, but I could mention. Can there be immunity to the criminal act of an elected member? Now, the bribe which was given outside the parliament or assembly, can it be claimed that there is a privilege when he speaks in the assembly, speaks for a particular person, speaks for the vote? Now, this was the question which was raised before the Supreme Court in 1998 in the matter of P.V. Narasimha Rao versus State of, that is the Delhi. And the observation placing such a member above law was not only be repugnant to the healthy functioning of the parliament, but also will subvert the rule of law. Now the United States, the Justice Bhaskar, as then he was, mentioned speech and debate clause has to be read broadly to effectuate its purpose of protecting the independence of the legislature, but its purpose was not to make members super citizen. So you do not become super citizen just because there is a privilege. I just mentioned this is in the context of recent development. Now coming to the issue of the legal system. Now, administrative reforms, particularly, unless the corruption goes out of the public administration, any amount of reforms will have no bearing on the purity. Now, the wings which are functioning, particularly the laws just now mentioned, at the national level there is a supreme body called Lokayukta. At the state level we have got a fantastic Lokayuktha. Other than there is a controller of accounts and controller of auditor controller and CBI, ED and enforcement department. Now there is a very big issues which are going on, particularly under the Money Laundering Act. Now, the wings which are functioning, why this corruption is rampant, despite of all such wings, despite of there is an enforcement authorities. I will give an example. We have got laws, Money Laundering Act, we have got the Prevention of Corruption Act. Now, Prevention of Corruption Act is directly deal with the corruption, Section 7 and Section 13 with the public officer, public servant. Section 8 and 9, person who gives the bribe or induces the corruption. Now, laws are very clear. But despite that, why there is a no fear of the law and the consequence of corruption? Now, under the principle, the Prevention of Corruption Act, till recently and in 2023, particularly in relation to demand and acceptance. Now, the presumption is required to be drawn under Section 20 of the Prevention of Corruption Act in case where there is a bribe is demanded and accepted. Now, Supreme Court says that demand and acceptance is a sine qua non for the proving the offence under Section 13 or Section 7. Now, sine qua non, particularly of demand and acceptance, is a very difficult task. Now, this also coupled with an intention. In addition to that, there was a huge debate relating to the sanction. Now, the public servant, even if he is caught red-handed, or if his assets is more than disproportionate to the note source, now if he is to be prosecuted, Section 19(1) requires a sanction from the competent authority. Now, this question was debated by the High Court, debated by the Supreme Court, and in 2013, a case from Karnataka, particularly related to one administrative officer, state of Karnataka versus IIPA. The Supreme Court said, because the section says, before taking cognizance, sanction is necessary. Now, this question was whether the FIR can be registered or not registered, whether the sanction is necessary or sanction is necessary only after the charge sheet is filed, after the investigation. So, initially the Supreme Court held that even before you could proceed with the complaint, you are required to have a sanction. Later on, there was a 3 judges bench judgment much earlier to that, which it had made that the sanction is necessary only at this time of taking cognizance. Now, that judgment was not noticed by the subsequent judgment, and now the matter is referred to the larger bench. Now, look, the lacunas in the law. Now, we talk about, because I worked in the Lokayukta, little experience in the Lokayukta, apart from the various examples of nature of corruption, how the corruption takes place. The lacunas in the Act, now there are 4 wings. There is a technical wing, there is a police wing, there is a judicial wing, and there is the administrative wing. Now, what are the areas, what are the jurisdiction of the Lokayukta? Now any complaint coming under 12, which will be inquired and this report is submitted to the government. Now government, if they accept the report, they may directly Lokayuktha to conduct an inquiry that is on the administrative side. There is an inquiry wing which conducts the inquiry and sends the report, Lokayuktha or Upalokayuktha sends a report under section 12(3) to the government. Now here comes the question. Now the report is based on an inquiry conducted by a judicial officer, competent judicial officer. Now this report goes to the government. Now the government has a power to accept or not to accept because it's a appointing of the competent authority. Now in one stroke they say report not accepted. Even though the person is highly corrupt, the report is not accepted, no further action is permissible. Now similarly on the criminal side, if he is caught or if the asset is disproportionate, now the sanction is against by the competent authority. Now the competent authority may grant, may not grant. If it doesn't grant, then the prosecution fails. Now what is the discretion of this? Now just now Vijay Bhaskar mentioned, they reduce the discretionary power. Now who will reduce this discretionary power of the elected body which takes a decision in the cabinet meeting? Now there is nothing like any law that says that you must consider all these parameters before you could grant or refuse. There is nothing in the why the sanctions should be granted or not granted. They delay it to the years. This matter came up to the High Court. Several warnings were given to the state government. Now this leads to protect the corrupt also. Now this makes fearless corruption. The people who are corrupt, they don't get fear. And you must be noticing, this is common, it is a public phenomenon, that being a corrupt is not a sin, which was thought of sin, but is not sin. Now, these officers can manage, so the discretion power which is there with every authority, every government, needs to be conditional. Discretion can be exercised. Now the discretionary powers in many of the aspects, now there is thought to be reduced. There are many of the aspects, discretionary powers in the criminal justice system also. Now this has happened, even in the judiciary also, there was a case. Now the sentencing in the corruption case only, now the sentence was reduced below the statutory minimum sentence. Then Supreme Court has to come very heavily on the judgment and to mention that you have no discretion to reduce it below the minimum. Now, this type of discretionary powers vested in the government, which also confer. Now, I'll give you an example. Right man also suffers the corruption is for example. Suppose if you have every qualification to get that particular job done or particular things done, you make an application, you show that everything is unqualified. Still you don't get. Because the person to decide that matter will keep it for some time, it will continue to keep. Now, unless you go and approach him, you may not get that work, it gets delayed. Now, the person who is right but does not get it immediately also makes the other man corrupt. He wants his job to be done earliest, he may approach. Person who is not entitled, he may bribe and get it done. Now, these are the discretionary misuse or abuse of the discretionary powers. The Enforcement Directorate of Enforcement, ED, Enforcement Directorate, under the Money Laundering Act. Now, what is the money laundering? Illegal accumulated wealth or money. Power is given to the Enforcement Directorate to seize it, attach it. A criminally earned money. Now the criminally earned money is any amount which is excess to the known source. It's deemed to be disproportionate, which is disproportionate is deemed to be illegally earned. So it becomes the money laundering and it is amenable for the enforcement. The investigation part is very, very important, particularly under the Corruption Act. Now, investigation directly for catching a person, you're accepting the bribe. Now, loopholes in the investigation. In the criminal justice system, most important part for the justice delivery is the investigation part. You all know that the investigation that is made results in filing of a charge sheet, and charge sheet is the only material based on which the prosecution is made. Now the investigating officer, if he is competent and is legally knowledgeable person, he would collect and preserve all the evidences that is necessary for the purpose of filing an appropriate charge sheet. If the defective charge sheet, I had an occasion to deal with a corruption case. It was a disproportionate asset to the known source. Now the prosecution has led 25 witnesses. They had led the evidence of 25 witnesses. Now 25 witnesses were all the witnesses which could have been examined by the defense. That is the government, delinquent government servant sister, father, father-in-law and other relatives. They come before the court to say that the amount which was lying with him is my money, that gold which was lying with him is my gold, and this is my money. That is what they went on. Now the defense lawyer does not cross-examine. He leaves it because the prosecution itself proved the case of the defense. Now this is the kind of prosecution because the witnesses which were examined by the police were all defense witnesses and they did not collect the repeated evidence. Now, and technology. Now the technology is very, very important. The police officer, if he is not well versed with the technology, now online frauds are there. Now the banking frauds are there. Now the scams are there. For example, the Harshad Mehta case, the original one, 1983 or 1993. I had an occasion to go to Supreme Court in that matter along with one of my senior advocate, which was a case of the stock market. And the Government of India constituted a special court for the Harshad Mehta case at Bombay. That was a special court against which there was no appeal even to the High Court. There was only one appeal to the Supreme Court. So, before Supreme Court we went. Now the banking fraud of such a nature, without even disclosing, the Maharashtra Bank was involved, so many banks were involved. Similarly, Satyam case. Now the Satyam case, the hidden account was different from the actual account. Now the actual account was hidden and the account which was shown as the prospectus of the company to increase the value of the stock. Now this type of frauds, they result into several thousands of crores of money. Now recently, you know, the banking frauds also, it may be Mallya, it may be Nirav Modi or many others. Now, these are all possible, and unless you know the technology, unless you are equipped with all the legal knowledge, unless you are equipped well, you are well trained, the police officer, like the casual way of investigation and submitting a charge sheet, that itself fails the prosecution. Now, Lokayukta under Lokayukta Act also, Lokayukta or Upalokayukta are not the police, they don't have the direct control on the police wing. The police wing functions under the Prevention of Corruption Act directly, and no investigation can be interfered by any authority, any court or Supreme Court also, once the investigation starts. Now, these investigations are directly under the police. Now, if the high profile personality against whom an investigation is to be made, if he is a subordinate or if he is under the control of such influential person, now the question is whether it is possible, fair investigation is possible. Now, for this, what is the solution? What is solution for this type of the weaknesses or the lacunas in the law? The first solution is whether it is a Lokpal, whether it is a Lokayukta, whether it is a CBI, whether it is a ED or anything, they must be independent of all these things. They should not be under any of the official, they must be directly under control of the President of India like a judicial wing, there must be a separate wing. Then only it is possible, the independence of inquiry, independence of the investigation. Then the prosecution. Now the prosecutor must be well equipped with the knowledge of the Prevention Corruption Act, it may be ED Act or anything. Now the prosecution, if it is weak, if it is not able to adduce the evidence which is necessary for proving the offence, this also. Now net result of these things is that minimum conviction rate will result that the fear, they take away the fear in the mind of a corrupt official, that even if he is caught 3-4 years, this case itself will go. Now this, to fulfill these type of lacunas, the independence of the authority is very, very important. Now the reforms which were just now mentioned, now we have the reforms also. We are now advancing by the technology also, and also there are a lot of information. For example, transparency in the public procurement. But there is also a provision which exempts from this, the transparency in case of urgency. And we don't know in what matter it becomes urgent and in what matter the government wants to procure certain things. Now, right to information is one of the weapons in the public hand, under which they get the information. But if you look at the number of case complaints pending before the Information Commission, it runs into thousands and pending for years also. Now, Sakala is also mentioned, where Sakala is time-oriented results. Now, the time-oriented results. Now, what is the effect of Sakala? Sakala is that if you file an application, 15 days you must get a result. Yes, definitely you get a result. What result you will get? You may get your result negative also. But you want to get a positive report, what to be done? Timeline is there. But then within the timeline, how do you get that result? Then it again question is, then whether it is again coupled with the corruption. Now, the administrative reforms. Now, Vijay Bhaskar ji, who headed the reform committee, has submitted the. Now, most important reforms that is necessary today is to know how to make the public office free from corruption. If the public office or the banks or the financial institutions are free from the corruption, now our budget, whether the state budget or the country's budget, we don't need to have anything from outside. We have enough resource, not only for us, we can feed it to others also. Now, apart from the direct involvement in corruption, there are other areas also. Now, the nepotism was mentioned. Now, the Prime Minister also mentions nepotism. Now, nepotism is something we are favoring your own kith and kin or your own relation. Now, the favoritism is also there. Now, these are the areas where if the officer or the person has a discretion. Now, once incidentally Vijay Bhaskar mentioned, it is a fact also. I tell you, in every department and every wing. For example, if I come here, now the Vice-Chancellor or the Principal has to offer me a bouquet and a book. Now, I don't know what is his budget. I don't know what is his sanctioning authority. But if he has to provide 5 books, 5 bouquets, now where from he get the money? If the money is restricted. Now this happened particularly in a law college function only, the University Law College function only. The sanctioning power of the principal was very, very minimal. And for everything he was to write to the university to get the sanction. Now we were in need, because it was a moot court competition, we were in need of the traveling pad, pen and other articles. Now the principal said I have to write it to the university. but for urgent, I can spend it from my pocket. Now this is where this happens. So then because it was our own program, then we provided these things. But I found that a principal of the law college has no authority to go beyond that particular limit. Now this is where, now to maintain a protocol, for example, even the officers who go to the other places, they have to be provided with proper accommodation, proper these things. Now here, this shortage of money, now he has to match with that. He has to match with, he may ask someone, he may directly pay the money, or ask someone to make arrangement for the guest. Now this relation, their favoritism comes. If that person has a work, never necessarily he has to do his work also. The favoritism in many aspects has resulted. Now the legacy of the state, the minerals, resources are the largest areas where huge chunk of the resource would vanish, and it did happen. So we need to have a complete check on the bodies, on the administration, on the persons dealing with the matters. Now the Right to Information Act gives the picture of that, but that is only an information which you get it, based on which either you have to go to the judicial, the court or the authority. Now even the judiciary itself is failing, because recent judgment in 2023 by the 5 judges bench, considering the scope of section 19, subsection 1 of the Prevention of Corruption Act relating to the sanction. Now they made, because direct evidence beyond reasonable doubt. What is beyond reasonable? In the criminal law we are very commonly use this. Beyond reasonable doubt you need to prove the offense. Now the beyond reasonable doubt was the question whether there should be a direct evidence, whether the person was taking a bribe, whether the person we have seen it, or there can be a circumstance if the person who was the witness, direct witness, dies. So these are all questions which came up before the Supreme Court, and Supreme Court and by the larger bench considered the circumstantial evidence in the absence of the direct evidence is possible. But at the same time, while interpreting section 7 and section 13, 1D, clause 2, they said that demand and acceptance are sine qua non for proving the offence in the section and section 13. Now, many cases there will not be a demand. Then they were to interpret it to say that prior demand, prior in time of demand. Now the acceptance of money by a public officer for no reason is nothing but a corruption. There is no need to harp on what he demanded and what he gave. Acceptance of a money, because anything that you are collecting illegally, other than what you are statutorily entitled, that is all illegal money which you are collecting. So this judgment again reiterated the requirement of section 7 and section 13. The office is particularly high-stake investigations, maybe CBI or ED. They take a lot of time. The investigation runs into months, sometimes years also. You must be commonly knowing it also, that they take a lot of time because collection of evidence. Collection of evidence from every corner, every possible witnesses. So it consumes a lot of time. Over the time, and by the time the trial comes before the court, that the time gap would be so huge. There was a typical case before the Supreme Court. A corruption complaint was of 1982. And the charge sheet came to be filed in 1991. And the conviction happened in 1999 by the Session Court. When it came before the High Court, it was 2003. And when it went before the Supreme Court, it was 2011. And now the Supreme Court has to address this, the delay also. Any agency, now why we are talking about this thing is, every institution connected with the, right from investigation to the judicial disposal of the case, there has to be time limit. If you don't have the time limit, if you run the investigation for 10 years, you're bound to happen that there are a lot of lacunas and a lot of lapses also, which resulted in the acquittal. Now, time limit is one of the requirements, and recently you must be familiar why some of the arbitration centers in other countries are doing very well than the India. For example, in Singapore Arbitration Center, which is a statutory arbitration center, the time limit is there. If the evidence has to commence on particular date and to end, it must end, no matter what it is. If the award has to come, it must come. Now, if you don't have this time limit, if you don't have the expertise on particular things, now whether it is judiciary, whether it is investigation, whether it is prosecution, whether it is defense, all these wings will fail. It's a typical example. 82 to 2011, that time taken for one case. Hence, my friends, the departments which are involved in this is, there need to be complete reform in the administration, and every such corruption charges must be looked very seriously. The punishment must deter the other intending or other person likely to commit. The criminal justice system object itself is to deter the other man from committing the crime. Now that is particularly in corruption, which is more than a cancerous, and it is compared with the terrorism, worse than terrorism. Terrorism, you can kill the person and be done with it, but here you cannot. It is cancerous, it is spreading like anything, and it has become common in day-to-day life. Everyone will experience, every moment you go, even if you want to enter the hall after some time, if you are late, give 5 rupees and get empty. Now, this tendency of a person giving also, there is a punishment for giver also. But hardly there are any instances of any person has been punished for having offered a bribe. Now, if the law is there, why you only look at from the person who collected? Person who offered is equally guilty and their punishment is also same. And that is to be seen, that we want to deter the person who is likely to offer, deter the person who is likely to accept. Now this type of the exercise is necessary, particularly if you bring everything in a timeline. Person caught is punished in 1 year, that will send the message to the others. So my submission for all of you is, because the law students are directly connected with the legal system, maybe it is investigation, maybe prosecution, or maybe the litigation side also. And very eminent personality on the dais, particularly Vijay Bhaskar, who headed that reforms committee, and now he is also in an Institute of Public Administration. That's why I asked him whether there is a training program, whether the officers are. The morality is more important. What is to be taught to the public officers is what is important. Now there are reasons, he mentioned it rightly. There are reasons because the poverty may be there, the capital, the per capita income may be the reason. But to solve that, necessary reforms are necessary. For if the inadequate salary is provided to a person, then he may not satisfy with that, he may indulge in corruption. Now this reform is necessary. Suppose if the facility, for the example, there is a principal of law college, what are the facilities he requires day-to-day administration? He need not go to beg before somebody to get it. he must be provided with that. These administrative reforms are necessary so that the mindset of a public officer or a public servant changes, that there is no need for you go to him, to any other person. He is self-satisfied. Reasonable salary, reasonable facilities, that must be the brought. Thirdly, morality has to increase, that they must be made responsible. That if the timeline is fixed, discretion must be exercised judiciously, and they must be free from the corruption in the mind. And the next is the enforcement authorities, the investigating. There must be special wing. Now, we don't have a special wing here. Any police officer can go investigate, but whether he has the knowledge, whether he has the background of the technology, without that, there is no point in investigating the matter, then the enforcement becomes fails. So there has to be expertise, there has to be special wing, they have to be independent, not coming under any of the administration or the government or the public servant. And thirdly, the prosecution must be very strong, independent and effective. And thirdly, timeline for disposal of the case. Then only that is a possible that the corruption cases can be easily and disposed of in a timeline, which may send the message to the others that in case anyone is corrupt or caught corrupt, that is likely to be punished. With this small keynote, I just want to conclude with a request to the law students that you are as responsible to the law faculty, particularly legal system, you are also responsible for social reforms also, because we have both the responsibility, because we come in contact with all kinds of cases. So if there is a need that you also get involved in the reformative act. And with this, I conclude my thank you.
Thank you, sir, for sharing such an experiential insights into the crevices and lacunas of law. For all of the law students and lawyers, advocates, and the faculty here to have a regime against anti-corruption. Now, before moving on to the address by our Honorable Vice-Chancellor, I would like to give a brief introduction of our Vice-Chancellor, sir. Professor Dr. Jayakara S M was born on 12 February 1969, having a lot of education qualifications such as BDS, MDS in Prosthodontics, Dean Plan for Finance, and having served as FTA Dean, Faculty of Dentistry at the RGU Health Sciences, Bangalore. He has a rich experience in different facets of education, teaching, research, and administration in the state and at the national level. He has served as a professor for more than 10 years and has also rendered his service as a vice principal and principal for 11 years at AECAS Maruti College of Dental Sciences and Research Center, Bangalore. He has been closely associated with Rajiv Gandhi University of Health Sciences since 2006 and had the unique privilege of working in all authorities of the RGUHS as Dean Faculty of Dentistry, Chairman Board of Studies Undergraduate, and as part of the Senate, the Syndicate, the Academic Council, the Finance Committee, and the Faculty of Dentistry during the last decade. Sir has also set the hallmark of spearheading Bangalore University as the Vice-Chancellor to be accredited as A++ by the NAC. Sir, therefore request you to address the guide.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. Very good morning, respected dignitaries on the dais, chief guest for today's program, Shri T.M. Vijay Bhaskar, former retired IAS officer, former Chief Secretary of Karnataka, former Chairperson, Karnataka Administrative Reforms Commission 2, and Chairperson IIPA-KRB, and keynote addressed by Hon'ble Justice Subhash B. Adi, the Chairman NGT State Level Committee Karnataka, former Lokayuktha and former Judge High Court of Karnataka, and guest of honor Professor Dr. N. Dasharath, former Chairperson and Dean, and presided by Professor Dr. V. Sudesh, Principal, Chairperson, Dean, and University Law College, Department of Studies in Law, Bangalore University. Professor Dr. Jyoti Vishwanath, Professor, University Law College. Dr. D. Jeevan Kumar, Secretary, IIPA. Professor Madhwaraj. Dr. Chandrakanti, Professor Satish Gowda, and all the faculty members of University Law College, and my dear students and research scholars. I wanted to share few examples which I have come across in my life. I think already Vijay, Bhaskar sir and Hon'ble Justice Subhash, they are the leader in their field. Already they have expressed their experiences, and it is an important topic which we are discussing today. And 5 years back, one of my close friend's son, and he has scored very good in NEET examination and state PUC examination. And he had gone for KEA for document verification. And from 8:30, he was waiting in the queue. And from 8:30, and 1 o'clock, he just entered that room, the person who is verifying the documents and uploading the document. And suddenly that person got up and said, you come after 1 hour. And this boy told, I have been waiting, uncle, please help me. Then he said, ನನಗೇನು ಕೊಡ್ತೀಯ? Uncle, ನನ್ನ ಹತ್ರ ಏನಿಲ್ಲ, ನನ್ನ ಹತ್ರ ಇರೋದು ಕೊಡ್ತೀನಿ. Then immediately sat and he finished that work. And after he came home and he was telling dad, ಈ ಥರ ಇನ್ಸಿಡೆನ್ಸ್ ಈ ಥರ ಆಯಿತು, ನಾನು ಕೊಟ್ಟೆ ಮಾಡಿದೆ, ಹೀಗಂತ ಗೊತ್ತಿದ್ರೆ ನಾನು 8:30ಗೆ ಅವ್ರ ಹತ್ರ ಹೋಗ್ತಾ ಇದ್ದೆ. ಅಂದರೆ ಈ ಮಕ್ಕಳಲ್ಲಿ ಯಾವ ಥರ ನಿಮಗೆ, ಈಗ ಹುಡುಗ ಮೆಡಿಕಲ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ, ಹೇಗೆ ಈ ಒಂದು ಇನ್ಸಿಡೆನ್ಸ್ ಅವರ ಇದರಲ್ಲಿ ಸೈಕಾಲಜಿ ಹೇಗೆ ಇದಾಗುತ್ತೆ ಅನ್ನೋಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇದ್ದಂಥದ್ದು. ಹಾಗಾಗಿ ನಮ್ಮ ದೇಶದಲ್ಲೂ ಹಾಗೆ ಈಗ present day more than 15 lakhs students, they go to abroad and study. ಅಂಡರ್ ಗ್ರಾಜುಯೇಷನಿಗೆ ಹೋಗ್ಬೋದು ಅಥವಾ ಪೋಸ್ಟ್ ಗ್ರಾಜುಯೇಷನಿಗೆ ಹೋಗ್ಬೋದು. ಅದ್ರಲ್ಲಿ ಎಷ್ಟು ಜನ ವಾಪಸ್ ಬರ್ತಾ ಇದ್ದಾರೆ ನಮ್ಮ ದೇಶಕ್ಕೆ ಬಂದು ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ನಿಮಗೆ ನನಗೆ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ಲಿ ನಾನು ಯಾರಾದರೂ ಹೋದ್ರೆ ನಾನು ಅವ್ರ ಪೇರೆಂಟ್ಸ್ ಹತ್ರ ಮಕ್ಕಳ ಹತ್ರ ಸಿಕ್ಕಿದಾಗ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಇಲ್ಲ ಅಂಕಲ್, ಅಲ್ಲೇ ಚೆನ್ನಾಗಿದೆ ಸಿಸ್ಟಮು, ಅಲ್ಲಿ ಏನು ಕಷ್ಟ ಇಲ್ಲ, ನಮ್ಮ ಇದು ಫಿಂಗರ್ ಟಿಪ್ಪಲ್ಲಿ ಕೆಲಸ ಆಗುತ್ತೆ. ಇಲ್ಲಿ ಸರ್ ಆಲ್ರೆಡಿ ಎಕ್ಸ್ಪ್ರೆಸ್ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸಿಗೆ ಹೋದರೆ ನಾವು ಕಷ್ಟಪಡಬೇಕು, ಈ ಪಾಸ್ಪೋರ್ಟ್ ಅಪ್ಲೈ ಮಾಡೋಕ್ಕೂ ನಾವು ಸಫರ್ ಆಗಬೇಕು, ವೀಸಾ ಅಪ್ಲೈ ಮಾಡೋಕ್ಕೂ ಒಂದೊಂದು ಇದರಲ್ಲೂ ನಾವು ಸಫರ್ ಆಗ್ತಾ ಇದ್ದೀವಿ ಅಂತ ಎಕ್ಸ್ಪ್ರೆಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಮೋಸ್ಟ್ ಆಫ್ ದಿ ಸ್ಟೂಡೆಂಟ್ಸ್ ಅಲ್ಲಿಗೆ ಹೋಗಿ ಆ ಸಿಸ್ಟಮಿಗೆ ಒಂದ್ಸಲ ಅಡ್ಜಸ್ಟ್ ಆದರೆ ಮತ್ತೆ ಈ ಕಡೆ ಬರಲಿಕ್ಕೆ ಕೇಳಲ್ಲ. ಈವನ್ ಲಾಸ್ಟ್ ಇಯರ್ ಸರ್, ನಮ್ಮ ಹಾನರಬಲ್ ಜಸ್ಟಿಸ್ ಅವರಿದ್ದಾರೆ, ವಿಜಯ್ ಭಾಸ್ಕರ್ ಅವರಿದ್ದಾರೆ, ನಮ್ಮ ಯೂನಿವರ್ಸಿಟಿ ರಿಸರ್ಚ್ ಸ್ಕಾಲರ್ಸಿಗೆ ನಾವು ಲ್ಯಾಪ್ಟಾಪ್ ಕೊಡಬೇಕಾಗಿತ್ತು ಸರ್. ಲ್ಯಾಪ್ಟಾಪ್ ಕೊಡಬೇಕಾಗಿತ್ತು. ನಾವು ಟೆಂಡರ್ ಕಾಲ್ ಮಾಡಿದ್ವಿ. ಟೆಂಡರ್ ಆಲ್ ಗೌರ್ಮೆಂಟ್ ಪ್ರೊಸೀಜರ್ಸ್ ನಾವು ಇದನ್ನೆಲ್ಲ ಫಾಲೋ ಮಾಡಿದ್ವಿ. ಆದರೆ ಒಂದು ಲ್ಯಾಪ್ಟಾಪಿಗೆ ಆಲ್ಮೋಸ್ಟ್ 1,30,000 ಲೀಸ್ಟ್ ಇರುವಂಥದ್ದು. ನಂತರ ನಾವೇನು ಮಾಡಿದ್ವಿ ಅಂದರೆ ಇದು ಆನ್ಲೈನಲ್ಲಿ ಚೆಕ್ ಮಾಡೋಕ್ಕೆ ಹೇಳಿದ್ವಿ. ನಾನು, ರಿಜಿಸ್ಟ್ರಾರು, ಫೈನಾನ್ಸ್ ಆಫೀಸರ್, ಸಂಬಂಧಪಟ್ಟವರೆಲ್ಲ ಕೂತ್ಕೊಂಡು ಇದು ತುಂಬ ಹೈ ಅನಿಸ್ತಾ ಇತ್ತು. ಇದು ಇಷ್ಟು ಕೊಟ್ಟರೆ ನಮಗೆ ಇಷ್ಟು ಲಾಸ್ ಆಗುತ್ತೆ, ಆಲ್ಮೋಸ್ಟ್ 200 ಲ್ಯಾಪ್ಟಾಪ್ ಪರ್ಚೇಸ್ ಮಾಡಬೇಕು ಅಂತ ಆ ಟೆಂಡರ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ವಿ. ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಮತ್ತೆ ನಮ್ಮ ವಿದ್ಯಾರ್ಥಿಗಳು ಅಷ್ಟೇ, ನಮಗೆ ಆ್ಯಪಲ್ ಲ್ಯಾಪ್ಟಾಪ್ ಬೇಕು ಸರ್, ಅದು ತುಂಬ ನಮ್ಗೆ ತುಂಬ ಇಷ್ಟ, ನೀವು ಅದನ್ನು ಕೊಡಿಸಿ ಅಂತೇಳಿ ನಾವು ನಂತರ ನಮ್ಮ ಕಂಪ್ಯೂಟರ್ ಸೈನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವ್ರನ್ನ ಇಂಟ್ರಾಕ್ಟ್ ಮಾಡಿ ಈ ಆ್ಯಪಲ್ ಹೆಡ್ ಇಸ್ ಕಂಪನಿ ಹೆಡ್ ಅವರನ್ನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿಕೊಂಡು ಕರೆಸಿ ಅವರಿಗೆ ನಾವೆಲ್ಲ ಬ್ರೀಫ್ ಮಾಡಿದ್ವಿ. ನಮ್ಮಲ್ಲಿ ಬರ್ತಾ ಇರುವಂಥ ಮಕ್ಕಳು ಎಲ್ಲ ತುಂಬ ಬಡತನದಿಂದ ಬರ್ತಾರೆ, ಎಲ್ಲ ಅವರೇ ಎಲ್ಲ ಫಸ್ಟ್ ಜನ್ರೇಷನ್ ಸ್ಟೂಡೆಂಟ್ಸು. ನಿಮಗೂ ಹೆಲ್ಪ್ ಮಾಡಿದಾಗತ್ತೆ ಈ ಒಂದು ಪ್ರೊಸೆಸ್ಸಲ್ಲಿ, ನೀವು ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಅಂತೆಲ್ಲ ಚರ್ಚೆ ಮಾಡಿದಾಗ ದೇ ಸೆಡ್ ನಮಗೆ ಈ ಪ್ರೈಸಿಗೆ ಸಿಗತ್ತೆ, ನಾವು ಒಂದು 1000 ರೂಪೀಸ್ ಇದ್ರ ಮೇಲೆ ಇಟ್ಕೊಳ್ತೀವಿ, ಬಟ್ ನಮ್ಮ ಇಲ್ಲಿ ನಮ್ಮ ಪೇಮೆಂಟ್ ಎಲ್ಲ ನೀವು ಕರೆಕ್ಟಾಗಿ ಮಾಡಬೇಕು, ಇಲ್ಲಿ ಎಲ್ಲ ಲಂಚ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡಬಾರ್ದು, ಅದೆಲ್ಲ ಮಾಡಿದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ ಅಂತ. ನಂತರ ಪುನಃ ಟೆಂಡರ್ ಕರೆದು ಅವ್ರ ಹತ್ರ ಅಪ್ಲೈ ಮಾಡೋಕ್ಕೆ ಹೇಳಿ, ನಂತರ ಅವ್ರದ್ದೇ ಲೋಯೆಸ್ಟ್ ಇತ್ತು ಅರೌಂಡ್ 70,000 ವಿದಿನ್ 80,000. ನಂತರ ಪ್ರೊಕ್ಯೂರ್ ಮಾಡಿ ನಾವು ಮಕ್ಕಳಿಗೆ ಕೊಟ್ವಿ. ಹಾಗಾಗಿ ವಿ ಆರ್ ಕಂಪೇರಿಂಗ್ ಕ್ಯಾನ್ಸರು ಮತ್ತು ಕರಪ್ಷನ್ ಅಂತ. ದೆರ್ ಇಸ್ ಅ ಟ್ರೀಟ್ಮೆಂಟ್ ಫಾರ್ ಕ್ಯಾನ್ಸರ್ ಪ್ರೆಸೆಂಟ್ ಡೇ and there is no treatment for corruption. And many times in my office also, many people they come, sir, and I wanted to, many they will say, we'll take care of you, sir, please do. And then I told them, if it is in the merit, definitely your tender or position will come. Sir, ಅದು ಮೆರಿಟ್ ಇದ್ರೆ ನಾನಿಲ್ಲಿ ಯಾಕೆ ಬರ್ತಾ ಇದ್ದೆ ಅನ್ನುವಂಥ ಭಾವನೆ. ಏನಂದ್ರೆ ಇದು ತುಂಬ ರ್ಯಾಂಪಂಟ್ ಆಗಿದೆ. ಈ ಒಂದು 2 days ಬ್ಯಾಕ್ ದೇರ್ ವಾಸ್ ಒನ್ ಆರ್ಟಿಕಲ್ ಇನ್ ಡೆಕ್ಕನ್ ಹೆರಾಲ್ಡ್. ಅವರ್ ಫಾರ್ಮರ್ RBI ಗವರ್ನರ್ ಹಸ್ ರಿಟರ್ನ್, ನಮ್ಮ ದೇಶದ ಏನು ನಾವು ವಿ ಆರ್ ಇನ್ ದಿ 3rd ಲಾರ್ಜೆಸ್ಟ್ ಗ್ರೋಯಿಂಗ್ ಇಕಾನಮಿ, ವಿ ಆರ್ ಇನ್ 3 trillion. ನಮ್ಮ ಬ್ಲ್ಯಾಕ್ ಮನಿ ನಮ್ಮ ದೇಶದಲ್ಲಿ 4 trillion ಇದೆ ಅಂತ ಅವರು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಸರ್ ಸಹ ಹೇಳಿದರು, ಜಡ್ಜಸ್ ಹೇಳಿದರು. ಆ ಥರ ನಮ್ಮ ಪರಿಸ್ಥಿತಿ ಇದೆ. ಇದು ಯಾವ ಡೈರೆಕ್ಷನಲ್ಲಿ ಹೋಗುತ್ತೆ ಅನ್ನೋದು ಗೊತ್ತಿಲ್ಲ. ಆದರೆ ಮೇಯ್ನ್ ಮಾಡಬೇಕಾಗಿರೋದು ಸಮಾಜ ಚೇಂಜ್ ಆಗಬೇಕು, ಇಂಡಿವಿಜುವಲ್ ಚೇಂಜ್ ಆಗಬೇಕು, ಪರ್ಸನ್ ಚೇಂಜ್ ಆಗಬೇಕು. ಪ್ರಾಪರಾಗಿ ಪೇರೆಂಟ್ಸು ಮಕ್ಕಳಿಗೆ ಚಿಕ್ಕ ವಯಸ್ಸಲ್ಲಿ ಇದ್ದಾಗಲೇ ಅವ್ರನ್ನ ಎಜುಕೇಟ್ ಮಾಡಬೇಕು. ಈ ನಮ್ಮ ಕರಿಕ್ಯುಲಮಲ್ಲಿ ಇದನ್ನು ತರಬೇಕು ಸರ್. ಕರಿಕ್ಯುಲಮ್ ಪ್ರೈಮರಿ ಎಜುಕೇಷನಲ್ಲಿ ಈ ಕರಪ್ಷನ್ನು, ದ ಇಲ್ ಇಫೆಕ್ಟ್ಸ್ ಆಫ್ ದಿ ಕರಪ್ಷನ್ನು ಹೇಗೆ ಆಗುತ್ತೆ, ಇದಕ್ಕೆ ಏನೇನು ಲಾಸ್ ಇದೆ, ಕಾನೂನು ಏನೇನಿದೆ, ಏನು ಪನಿಷ್ಮೆಂಟು, ಇದು ಈ ಕ್ಯಾನ್ಸರ್ ಅಂದರೆ ಒಂದು ಚಿಕ್ಕ ಫ್ಯಾಮಿಲಿಗೆ ಎಫೆಕ್ಟ್ ಆಗುತ್ತೆ, ಇದು ಎಂಟೈರ್ ಕಂಟ್ರಿ ಡೆವಲಪ್ಮೆಂಟ್ ಮೇಲೆ ಎಫೆಕ್ಟ್ ಆಗುತ್ತೆ. ಹಾಗಾಗಿ ಇದನ್ನ ಒಂದು ಪ್ರೈಮರಿ ಎಜುಕೇಷನಲ್ಲೇ ಇದನ್ನ ತಂದರೆ, ಮಕ್ಕಳಲ್ಲಿ ಪರಿವರ್ತನೆ ತಂದರೆ ಇದನ್ನ ತಡೆಗಟ್ಟಬಹುದು ಅನ್ನುವಂಥದ್ದು ನನ್ನ ಅನಿಸಿಕೆ ಸರ್. ಈಗಾಗಲೇ ತುಂಬ ನಮ್ಮ ವಿಜಯ್ ಭಾಸ್ಕರ್ ಸರ್ ಇಸ್ ಒನ್ ಆಫ್ ದಿ ಬೆಸ್ಟ್ ಅಂಡ್ ಇಸ್ ವೆರಿ ಗ್ರೇಟ್ ಆಫೀಸರ್, ಫೈನೆಸ್ಟ್ ಆಫೀಸರ್ ವಿಚ್ ವಿ ಹ್ಯಾವ್ ಸೀನ್ ಇನ್ ಅವರ್ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ. ಆ್ಯಂಡ್ ಈವನ್ ನಮ್ಮ ಜಸ್ಟಿಸ್ ಸರ್ ಅಷ್ಟೇ, ಲೋಕಾಯುಕ್ತದಲ್ಲಿದ್ದವರು, ತುಂಬ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇದೆ, ಅದ್ರ ಬಗ್ಗೆ ತುಂಬ ವಿವರಣೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಾನು ಹೆಚ್ಚೇನು ಮಾತಾಡಲಿಕ್ಕೆ ಹೋಗಲ್ಲ. ಇದು ಈಸ್ ಅ ವೆರಿ ಗುಡ್ ಫೋರಮ್. ನೀವೆಲ್ಲ ಲಾ ಸ್ಟೂಡೆಂಟ್ಸ್ ಆಗಿರೋದ್ರಿಂದ ನೀವು ಯು ವಿಲ್ ಕಮ್ ಅಕ್ರಾಸ್ ಇನ್ ಯುವರ್ ಲೈಫ್. ದಯವಿಟ್ಟು ಇದನ್ನು ತಡೆಗಟ್ಟೋದು, ಹೇಗೆ ಕಂಪ್ಲೀಟ್ಲಿ ಇರಾಡಿಕೇಟ್ ಮಾಡೋದು, ನೀವೆಲ್ಲ ವರ್ಕ್ ಮಾಡಬೇಕು. ಸ್ಟೂಡೆಂಟ್ಸ್ ಮೂವ್ಮೆಂಟ್ ಸ್ಟಾರ್ಟ್ ಆಗಬೇಕು. ಇದರಿಂದ ಮಾತ್ರ ಇದನ್ನು ಸ್ಟಾಪ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಅಂತ ಹೇಳ್ತಾ ನನ್ನ 2 ಮಾತು ಮುಗಿಸ್ತೀನಿ.
Thank you, sir, for such a warm address to the gathering. Now I request the guest of honor, Professor Dr. N. Dasharath, sir, former Chairperson and Dean University Law College, Department of Studies in Law, to address the gathering.
ಈ ಒಂದು ಸುಂದರ ಸಮಾರಂಭದಲ್ಲಿ ಸಾಮರ್ಥ್ಯವನ್ನು ಕಟ್ಟುವ ಒಂದು ಕಾರ್ಯಾಗಾರದಲ್ಲಿ ಉಪಸ್ಥಿತರಿರುವ ಪ್ರಾಮಾಣಿಕ ಗೌರವಾನ್ವಿತ ಅತಿಥಿ ಮತ್ತು ಮುಖ್ಯ ಅತಿಥಿಗಳಾದಂಥ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿಗಳೇ, ಶ್ರೀ ಸುಭಾಷ್ ವಿ ಆದಿ ಸಾಹೇಬ್ರೆ, ಚೇರ್ಮನ್ ನ್ಯಾಷನಲ್ ಗ್ರೀನ್ ಟ್ರಿಬ್ಯುನಲ್, ಮತ್ತೊಬ್ಬ ಬಹಳ ಪ್ರಾಮಾಣಿಕವಾದಂಥ ರಾಜ್ಯ ಮಟ್ಟದ ಅಧಿಕಾರಿ ಶ್ರೀಮಾನ್ ವಿಜಯ್ ಭಾಸ್ಕರ್ ಸಾಹೇಬ್ರೆ, ಬಹಳ ಪ್ರಾಮಾಣಿಕತೆಯಿಂದ ಕೆಲಸವನ್ನು ನಮ್ಮ ವಿಶ್ವವಿದ್ಯಾಲಯದಲ್ಲಿ ನಿರ್ವಹಿಸ್ತಾ ಇರತಕ್ಕಂಥ ಗೌರವಾನ್ವಿತ ಕುಲಪತಿಗಳಾದ ಡಾಕ್ಟರ್ ಜಯಕರ್ ಎಸ್ ಎಂ ಸಾಹೇಬ್ರೆ, ಎರಡೈಟ್ ಪ್ರೊಫೆಸರ್ಸ್ and scholars, Professor Jeevan Kumar, Professor Madhwaraj sir, respected principal chairman, Professor V. Sudesh sir, respected members of my faculty, Professor Satish, Professor Jyoti, Professor Chandrakanti, most importantly the coordinator of today's function, who has organized this in a very effective way to build in some sort of capacity in all of us to resist against the deadly evil of corruption. This function is organized under the able coordinatorship of Professor Jyoti Vishwanath, research scholars, students of postgraduate LLM, and dear students of undergraduate courses. Enough ink has been spent, heaps of pages are also spent against the deadly evil of corruption. But then I wanted to just within a few minutes look at this problem in social legal context. Firstly, ನಮ್ಮ ಕರ್ನಾಟಕ ಪ್ರದೇಶ ರಾಜ್ಯ, ಮೊದಲು ಮೈಸೂರು ರಾಜ್ಯ ಅಂತ ಹೇಳ್ತಾ ಇದ್ವಿ. ಈ ರಾಜ್ಯವನ್ನು ಆಳಿರತಕ್ಕಂಥ ಒಡೆಯರ ಅರಸರ ಸಾಮ್ರಾಜ್ಯದಲ್ಲಿ ಎಷ್ಟೊಂದು ಮೊದಲಿಗೆ ಅಂದರೆ ಪ್ರಥಮರಾಗಿದ್ದರು ಅವರು ಅಂತಂದರೆ ಒಂದೆರಡು ಮೂರು ಉದಾಹರಣೆಗಳು ನಾನು ನಿಮ್ಗೆ ಹೇಳ್ತೀನಿ. 2 or 3 examples I tell you. The first example is that during the Wadiyar's rule in Mysore, vaccination program was initiated for the first time in the entire country. Second, for the first time, education for the girl child was initiated in the entire country. For the first time, the provision for reservation for the depressed classes was introduced in the Wadiyar's Mysore Samraj. When there was initiative for education for the girl child, reservation in education for the depressed classes, other backward classes, some members of the Muslim community went to the king and put forward a request urging the king that he should not make compulsory education for the children of Muslim Samaj, because the children are a great source of help, who work and contribute to our family. ಅವ್ರು ಟಂಗ ಓಡಿಸೋರು, ಟಂಗವಾಲ ಜನರೆಲ್ಲ ಹೋಗಿ ಕೇಳಿದ್ರು ರಾಜರಿಗೆ. ರಾಜರು ಹೇಳಿದ್ರು, ಆಯಿತು, ನೀವು ಎಷ್ಟು ದಿನಕ್ಕೆ ದುಡಿತೀರೋ ಟಾಂಗ ಓಡಿಸ್ಬಿಟ್ಟು ನಮ್ಮ ಸಾಮ್ರಾಜ್ಯದಲ್ಲಿ, ಅಷ್ಟು ದುಡ್ಡು ನಾನು ಭಾನುವಾರದಿಂದ ಶನಿವಾರದವರೆಗೆ ಎಷ್ಟಾಗುತ್ತೋ ಅಷ್ಟು ನಾನು ಕೊಡ್ತೀನಿ. ನೀವು ಮಕ್ಕಳನ್ನೆಲ್ಲ ಶಾಲೆಗೆ ಕಳಿಸಿ. ಹಾಗೆ ನಾವು ಇಷ್ಟೆಲ್ಲ ಮೊದಲು ಬಿಗಿನರ್ಸ್ ಆಗಿ ಇನ್ ದಿ ಕಂಟ್ರಿ, ಮೊದಲಿಗರಾಗಿ ನಾವೀಗ ಯಾವ ಮಟ್ಟಕ್ಕೆ ಸೇರಿದ್ವಿ, where we have reached on this day on which we are debating about the capacity building against corruption with legal intervention. With best of my knowledge, I feel that ನಾವು ಸಮಾಜದಲ್ಲಿ ಎಷ್ಟು ಸಾಧ್ಯವಾಗುತ್ತೋ ಅಷ್ಟು ಕ್ರಿಯೇಷನ್ ಆಫ್ ಅವೇರ್ನೆಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತೋ ಅಷ್ಟರ ಮಟ್ಟಿಗೆ ನಾವು ಮಾಡಬೇಕು. ಗೌರವಾನ್ವಿತ ಕುಲಪತಿಗಳು ಬಹಳ ಒಳ್ಳೆ ಒಂದು ಅಡ್ವೈಸ್ ಅನ್ನು ಕೊಟ್ಟರು. ಯಾಕೆಂದ್ರೆ ಆ ಅಡ್ವೈಸ್ ವಿಲ್ ಮ್ಯಾಚ್ ಟು ದಿ ಅಡ್ವೈಸ್ ಗಿವನ್ ಬೈ ಅವರ್ ಫಾರ್ಮರ್ ಪ್ರೆಸಿಡೆಂಟ್ ಲೇಟ್ ಶ್ರೀ ಅಬ್ದುಲ್ ಕಲಾಂ. ಯಾಕಂದ್ರೆ ಲೇಟ್ ಶ್ರೀ ಅಬ್ದುಲ್ ಕಲಾಂ ಅವರು ಒಂದು ಸಭೆಯನ್ನು ಉದ್ದೇಶಿಸಿ ಮಾತನಾಡುವಾಗ ಒಬ್ಬ ಚಿಕ್ಕ ಮಗು ಎದ್ದು ಬಿಟ್ಟು, ಸಾಹೇಬ್ರೆ, ನಮ್ಮ ದೇಶದಲ್ಲಿ ಭ್ರಷ್ಟಾಚಾರವನ್ನು ಹೇಗೆ ಆಳಿಸಬಹುದು, ಹೇಗೆ ಕಡಿಮೆ ಮಾಡಬಹುದು ಅಂತ ಕೇಳಿತು ಮಗು. ಆ ಮಗು ಕೇಳಿದಾಗ ಅಬ್ದುಲ್ ಕಲಾಂ ಸಾಹೇಬರು ಬಹಳ ಸ್ಮೈಲಿಂಗ್ ಮಾಡ್ತಾ ಫ್ರೆಂಡ್ಲಿ ಆಗಿ, ಮಗು, ಅದು ನಿಮ್ಮಿಂದಲೇ ಸಾಧ್ಯ ಆಗುತ್ತೆ ಮಗು ಅಂತ ಹೇಳಿದ್ರು. ಹೇಗೆ ಸರ್ ನಮ್ಮಿಂದ ಸಾಧ್ಯ ಆಗುತ್ತೆ? ನೋಡಿ, ಮಕ್ಕಳು ಮನೆಯಲ್ಲಿ ನಿಮ್ಮಪ್ಪ ಅಥವಾ ಅಮ್ಮಂದರು ಯಾರಾದರೂ ಒಳ್ಳೊಳ್ಳೆ ಬಟ್ಟೆಗಳನ್ನು ತಂದರೆ, ಒಳ್ಳೊಳ್ಳೆ ನಿಮಗೆ ಟಾಯ್ಸ್ ತಂದರೆ, ಒಳ್ಳೊಳ್ಳೆ ಎಲ್ಲ ಭಾಳ ಲಕ್ಸುರಿಯಸ್ ಐಟಮ್ಸ್ ನಿಮಗೆ ಪ್ರೊವೈಡ್ ಮಾಡಿದ್ರೆ, ಅಪ್ಪ ಇದು ದುಡ್ಡು ತರಕ್ಕೆ ಎಲ್ಲಿಂದ ಬಂತಪ್ಪ ಅಂತಂದು ಕೇಳಬೇಕು. ಹಾಗೆ the awareness should begin from the child to the eldermost in the family, and this will be a social measures for the eradication of corruption in society, what I feel. You know how many tons of golds we import every year? Can anybody say? I stand corrected if I am wrong. Around 100 tons of gold is imported every year by our country. ಮೊದಲು ಗೋಲ್ಡ್ ನಾವು ಯಾಕೆ ಇಟ್ಕೊಳ್ತಾ ಇದೀವಿ ಮನೆಯಲ್ಲಿ? ಚಿಕ್ಕ ಮಟ್ಟದಿಂದ ದೊಡ್ಡ ಮಟ್ಟದ ಗೋಲ್ಡ್ ಅನ್ನು, ಸ್ಮಾಲ್ ಅಮೌಂಟ್ ಟು a larger amount of gold we used to keep just for our security in life. ನಮ್ಮ ಭದ್ರತೆಗಾಗಿ ನಾವು ಗೋಲ್ಡ್ ಅನ್ನು ನಾವು ಕೊಂಡ್ಕೊಳ್ತಾ ಇದ್ವಿ, ಇಟ್ಕೊಳ್ತಾ ಇದ್ವಿ. ಕಷ್ಟ ಕಾಲಕ್ಕೆ ಬಂದು ಗೋಲ್ಡ್ ಅನ್ನ ಪ್ಲೆಡ್ಜ್ ಮಾಡಿ ನಮ್ಗೆ ಬಂದಿರತಕ್ಕಂಥ ಕಷ್ಟವನ್ನು ಪರಿಹರಿಸಬಹುದು. ಆದರೆ ಬರ್ತಾ 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 ಗೋಲ್ಡ್ ಬಿಕೇಮ್ ಆರ್ನಮೆಂಟಲ್ ಮೆಟಲ್. ಫ್ರೆಂಡ್ಸ್, ಅನ್ಯತಾ ಭಾವಿಸ್ಬೇಡ್ರಿ. ನಮ್ಮ ಅನಂತ ಪದ್ಮನಾಭ ಸ್ವಾಮಿ ಟೆಂಪಲ್ ನಲ್ಲಿ ಎಷ್ಟಿದೆ ಗೋಲ್ಡ್? ಸಿದ್ಧಿವಿನಾಯಕ್ ಟೆಂಪಲ್ ಬಾಂಬೆದಲ್ಲಿ ಎಷ್ಟಿದೆ ಗೋಲ್ಡ್? ತಿರುಪತಿ ಸ್ವಾಮಿ ವೆಂಕಟೇಶ್ವರ ದೇವಸ್ಥಾನದಲ್ಲಿ ಗೋಲ್ಡ್ ಎಷ್ಟಿದೆ? ಸರ್ಕಾರ ಒಂದು ಸರ್ತಿ ಕೇಳಿದ್ರು, ನಿಮ್ಮ ಹತ್ರ ಗೋಲ್ಡ್ ಅನ್ನ ನಮ್ಗೆ ಸ್ವಲ್ಪ ಕೊಡಿ, ನಾವು ದೇಶದ ಪ್ರಗತಿಗಾಗಿ ಇದನ್ನು ಬಳಕೆ ಮಾಡ್ತೀವಿ. ಹಾಗಾಗಿ ನಮ್ಮ ಪ್ರಧಾನಮಂತ್ರಿಗಳು ಗೋಲ್ಡ್ ಬಾಂಡ್ಸ್ ನ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಕಾನ್ಸೆಪ್ಟ್ ನ. ಎಷ್ಟು ಜನ ನಾವು ಗೋಲ್ಡ್ ಬಾಂಡ್ಸ್ ನ ಕೊಂಡ್ಕೊಳ್ತಾ ಇದ್ದೀವಿ. ಹಾಗೆ ನಾವು ಬಚ್ಚಿಟ್ಟು 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 ಮುಚ್ಚಿಟ್ಟು, ಯಾರು ನಾವು ಸತ್ತ ಮೇಲೆ ನಾವು ಬಚ್ಚಿಟ್ಟು ಮುಚ್ಚಿದ್ದನ್ನ ನಾವು ಅಂತ ಅನುಭವಿಸಕ್ಕಾಗಲ್ಲ. ಹಾಗಾಗಿ ಒಂದ್ಸರ್ತಿ ಆದಿ ಶಂಕರಾಚಾರ್ಯ ಸಾಹೇಬರು ಸ್ವಾಮಿಗಳು ಒಂದು ಬೀದಿಗೆ ಹೋಗ್ತಾರೆ ಭಿಕ್ಷಾಂದೆ ಅಂತ, ನೋಡೋಣ ಜನಗಳಲ್ಲಿ ಹೇಗಿದೆ ಒಂದು ಪ್ರವೃತ್ತಿ ದಾನ ಮಾಡೋದು. ಒಂದು ಮನೆಗೆ ಹೋಗ್ತಾರೆ, ಅವರು ಮನೆಯಲ್ಲಿರೋರು ಒಬ್ರು ಹಿರಿಯರು ಬರ್ತಾರೆ ಹೊರಗಡೆ, ನೋಡ್ತಾರೆ, ಓ ಮಹಾನ್ ಸ್ವಾಮಿ ಯಾರೋ ಬಂದಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ತಗೊಂಡು ಬಂದು ಸ್ವಲ್ಪ ಧಾನ್ಯವನ್ನು ಹಾಕ್ತಾರೆ, ಜೋಳಿಗೆಗೆ ಹಾಕ್ತಾರೆ. ಸ್ವಾಮಿಗಳು ಆ ಒಂದು ಧಾನ್ಯವನ್ನು ತಿರಸ್ಕರಿಸ್ತಾರೆ, ನನಗೆ ಬೇಡ, ನಾನು ಸ್ವಲ್ಪ ಹೊತ್ತು ವಿಶ್ರಾಂತಿ ತಗೊಳ್ತೀನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವ್ರು ಪಡಸಾಳೆ ಕಟ್ಟೆಯಲ್ಲಿ ಸ್ವಲ್ಪ ಹೊತ್ತು ಕೂತ್ಕೊಂತಾರೆ. ಕೂತ್ಕೊಂಡು ಹಿಂಗೆ ನೋಡ್ತಾರೆ, ಬ್ಯಾಗ್ಸ್, ನಂಬರ್ ಆಫ್ ಬ್ಯಾಗ್ಸ್ ಫಿಲ್ಡ್ ವಿತ್ ರೇಷನ್. ಎರಡು ಕಟ್ಟೆಗಳಲ್ಲಿ, ಪಡಸಾಳೆ ಕಟ್ಟೆಗಳಲ್ಲಿ ಲಾಟ್ ಆಫ್ ಬ್ಯಾಗ್ಸ್ ಆಫ್ ರೇಷನ್ is stored. But the man came with a little portion of grains as an arm to the Swami. Then Swami asked, why have you stored all these grains here? Swami, ನಮ್ಗೆ ಬೇಕು ಇವೆಲ್ಲ. Why? ಯಾಕೆ ಬೇಕು? ಇದನ್ನ ಸಮಾಜದಲ್ಲಿ ಹಂಚಬೇಕು, ಇದನ್ನ ಇಲ್ಲ ಮಾರಬೇಕು, ನಿಮ್ಗೆ ಎಷ್ಟು ಬೇಕು ಧಾನ್ಯ ಅಷ್ಟು ಇಟ್ಕೋಬೇಕು ನೀವು, ಮಿತಿ ಮೀರಿ ಧಾನ್ಯವನ್ನು ಇಟ್ಕೋಬಾರದು. Means the concept is very simple. Don't try to concentrate wealth with one or many in the society. And this is a constitutional mandate that the state shall strive all its best to avoid the concentration of wealth in one an institution or a human being or whatsoever. How far we have fulfilled this constitutional mandate, let us ask for ourselves. Our Hon'ble Vijay Bhaskar ji said, lot of reforms have been introduced, have been recommended. Excellent. Our Honorable Justice also has said about the role of the Lokayuktha. It's merely a recommendatory body. ATR upon the recommendation, action taken, report upon the Lokayuktha is not taken seriously. And there are so many examples where the Lokayuktha recommended that such an officer is involved in corruption, but he is promoted to the highest post. All these examples are there. And there was one very glaring example, I believe, for the first time in our state, when Mr. Dhananjay Kumar was the commissioner of the Bangalore Mahanagar Palike, was jailed for 1 day for violating the Contempt of Court Act. 1 day. ಪಾಪ ಅವರು ಬಹಳ ಪ್ರಾಮಾಣಿಕವಾದಂಥ ಅಧಿಕಾರಿ ಅಂತೆ. ನ್ಯಾಯಾಲಯ ಕೊಟ್ಟಿರುವ ಆಜ್ಞೆಯನ್ನು ಅವರು ಪರಿಪಾಲಿಸಲಿಲ್ಲ. ಅದಕ್ಕಾಗಿ ಶಿಕ್ಷೆ ಯಾರಿಗೂ ಇತ್ತು? ಆ ಪ್ರಾಮಾಣಿಕ ಅಧಿಕಾರಿಗೂ ಇತ್ತು. ಏನು ಅವ್ರು ಜೈಲಲ್ಲಿದ್ದಾಗ ಈ ಪ್ರಾಮಾಣಿಕವಾದಂಥ ರಾಜಕಾರಣಿಗಳು ನೋಡಿದ್ದ, ಅಯ್ಯೋ ಹಿಂಗಾಯ್ತು, ಅಯ್ಯೋ ಹಿಂಗಾಯ್ತು. So therefore, I feel that the Contempt of Court Act teach should be strengthened. Because there is no fear of the court orders in the society, especially in the higher rank of the society. Court order maadana bidri. There are a lot of impediments in the implementation of the Contempt of Court Act. ಎಷ್ಟು ಪ್ರಾಮಾಣಿಕವಾಗಿ ನ್ಯಾಯಾಲಯ ಸಾಕ್ಷ್ಯಾಧಾರಗಳನ್ನು, ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಕಾನೂನನ್ನು ಅಪ್ಲೈ ಮಾಡಿ ಕೊಟ್ಟಿರತಕ್ಕಂಥ ಆಜ್ಞೆಗಳನ್ನು ಎಷ್ಟು ವರ್ಷಗಳಾದರೂ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡದೇ ಇದ್ದರೆ ಇನ್ನು ಈ ಸಮಾಜದಲ್ಲಿ ಯಾರಿಗೆ ಹೇಗೆ ಭಯ ಇರುತ್ತೆ ಇನ್ನು ಯಾವುದ್ರ ಬಗ್ಗೆ? ಸೊ ದಿಸ್ ಐ ಫೀಲ್ ಈಸ್ ಒನ್ ಆಫ್ ದ initiative would be taken as a reform, because ultimately in a democracy the government is responsible to the people. It's a collective responsibility. So therefore, with these few words, I am extremely happy to be the part of this function, and I am extremely happy for giving me the opportunity to say few words. Before concluding, our Honorable Vice-Chancellor has started a new initiative. You know, last 1 month back, if I am right, he had invited all the professors in his chambers, and he was asking, what are the problems which you are facing? Where I have to intervene? And now I have to solve. Please come out with the problems. Beautifully, the problems were told to the Honorable Vice-Chancellor, other statutory officers, the Honorable Registrar, Finance Officer, the full team, Registry Relation, the Vice-Chancellor had come there. And so beautifully, he has started addressing the problems, one by one. Another example in Bangalore University I have seen is that there was one officer in the Registry for Evaluation, case officer. Every day he used to first go to the inward clerk. Now inward clerk table hatra ಹೋಗ್ಬಿಟ್ಟು ಸಾಯಂಕಾಲ ಹೋಗ್ತಾ ಇದ್ರು ಅವರು ತೋರ್ಸು ಯಾವ ಬಂದಿದೆ ಪತ್ರಗಳು ಇವತ್ತು ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? ಎಂಟ್ರಿ ಮಾಡಿದ್ವಿ. ಯಾಕೆ ಇಟ್ಕೊಂಡಿದ್ದೆ ಈ ಪತ್ರ ಇವತ್ತು ಇಲ್ಲಿ? ಯಾಕೆ ಕಳಿಸಿಲ್ಲ ಮೀನಕ್ಕೆ? Used to alarm that poor clerk and tell him, ನೀನ್ಯಾಕೆ ಇಟ್ಕೊಂತೆ? Come on. Immediately ನೀನು ಕಳಿಸ್ಕೊಡ್ಬೇಕಿದ್ದ ಮೇಲಾಧಿಕಾರಿಗಳಿಗೆ ಅವ್ರ ಕ್ರಮ ಕೈಗೊಳ್ತಾರೆ ಹೇಳಿದ್ದಾರೆ. Likewise, used to go to the outward clerk also and ask, ಯಾಕೆ ಇಟ್ಕೊಂಡಿದೆ ಇದನ್ನು? ಬೇಗ ಕಳಿಸೋದು ಆಕ್ಷನ್ಗೆ. ಸೊ ಈ ಥರ ಪ್ರಾಮಾಣಿಕವಾದಂಥ ಅಧಿಕಾರಿಗಳು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಅಲ್ಲಿ, ಯಾಕಂದ್ರೆ ಇನ್ವರ್ಡ್ ಅಂಡ್ ಔಟ್ವರ್ಡ್ ಸೆಕ್ಷನ್ಸ್ ಆರ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. Very important. The disposal of files. Some officers used to write in the file, excellent, speedy. They used to appreciate the speed of the file and write a note there. I appreciate the speed of the file which has come to me for disposal. So an encouragement for the lower rank of administration to work in time and accordance with law. With these few words, I thank you, all of you. Jai Hind, Jai Karnata. Thank you.
Thank you, sir, for such an enlightening and warm address to the gathering. Now, before moving on to the presidential address, I'd like to give a brief anecdotal introduction about our principal, chairperson, and dean, Professor Dr. Vijay. All right, we'll just move on to the question and answer session for now before the presidential address. If you have any questions, you may raise your hand. We'll pass you the mic and you can ask a question to the dais. We have a question with us right here, sir. So the question goes on, especially to Justice Subhash, sir. Sir, what's your take on the regime against white-collar crimes in India as of now?
Now this trend has begun. Other day, I had one law student, Internee, and she said she is interested in fighting litigation, white collar litigation. Now, what is this white collar litigation? I came across it's a new word for me. She said the corruption cases, because rampant corruption is there, lot of white collar, because the money transactions, ED cases, ministers involved, top bureaucrats are involved. So I want to practice on that. And today, if you say that there is a white collar cases, there are an empty number of white collar litigation, that means the level of corruption is so high and so rampant, and even legal system also wants to have a branch on that particular system. This phenomena of white collar practice has developed recently, and most of them are trying to get involved in these things.
So there's another question. In view of the rising e-governance and the white-collar crimes, what's your take on the digitalization of the governance process and corruption in India?
Digitalization is one of the most important technology. For example, I was particularly the branch which I am now heading. There it was canvassing, particularly having visited Indore as a clean city. Now I found that the entire advertisement system was on the digital. Now it reduced the paper and plastic also, so there is the clear cut. Now it also reduced the corruption. Now digitalization ensures that the person entitled and person to offer, the whole thing will go online and recorded and accountability. And this also reduces the expenditure on the budget also, particularly if you have today most of the cases. Now we have adopted a system. I can little go further and mention that High Court and the Judiciary has adopted online filing. And I was in Delhi. Now the entire Delhi High Court has become e-court. Now every judge has got the display desk and everything is on monitor. Now the effect of this is complete prevention of paper, complete stoppage of the paper used in the litigation, except for the file. Now this digitalization and online filing, and in arbitration also we get only online papers. So if you want to, you can download it. But the amount of time you save, the amount of money you save, and the clarity that it is there on the record. Today there was one award which was to give it to the party. That immediately the secretary made a note and they sent it. There is no need to, one signed copy will remain with it and another will go to the party. Rest of things go in the online. So digitalization in banking system is most important. Now, huge scams are in bank particularly. If you look at the NPA, non-performing accounts, and the volume of non-performing accounts, all these are because of the manual entries, manual and manipulations. If everything is digitalized and it made computerized completely, so I think that the percentage of corruption may come down.
Thank you, sir. There's another question with a context. In reference to the RTI applications and the RTI regime going on in India, what's your take, considering all of these developments, on the misuse of redressal mechanisms in India through corruption? Redressal mechanisms in India through corruption. This is a question to the entire dais.
Now, there are two things in here, and Vijay, Bhaskar must be knowing it. RTI plays one for the public good, and there are some people, unscrupulous people. Because I experienced as a experience. I experienced as an Lokayukta. We used to get the complaints. RTI activists used to come and file a complaint against some of the officials. They used to get the information from the Right to Information Commission. Based on that, they used to file a complaint. After filing the complaint, they used to meet the officer. that I have filed a complaint before the Lokayuktha, and I will prosecute you. Now, the officer, if he is guilty and he knows that he has to be protected himself, he may yield to his request. And this is the one type of modus operandi some of the unscrupulous RT activists indulge in that. But some genuine cases, most of the cases where this information gave a very good inputs to the investigation agencies as well as enforcement authorities and Lokayuktha to take an action. Many a times we don't get the information. But when this type of information which is available will definitely help to purify the administration and bring a change. Yes.
Hello, sir. So I have a question. How far is the judiciary independent in dealing with these corruption cases, sir?
Now, judiciary primarily, very meaning of judiciary itself is that it is independent. It must be independent and it is independent. Maybe one or two instances, and I cannot disown it, there was a case of impeachment of one of the judge also, the Calcutta High Court judge also, and one judge resigned. It doesn't, there is some kind of, maybe if you call it as a corruption, may not be corruption, but influences or favoritism may be there. Nevertheless, because of the strong judiciary and strong action, if you look at because you're all law students, you must be very familiar with the constitutional law. Now if you take the draft constitution, and there are first part, third part of the constitution is the fundamental rights. Now fundamental rights, under the fundamental, if you read as text as it is, you may not understand. For example, Article 21 is the life and liberty. Now by life and liberty, what do you understand? Life and liberty, what they guarantee you are giving it to the people. Now the life and liberty was explained by umpteen number of Supreme Court judges to make it known that life means that dignified, live with the dignity, right to education, right to health, right to shelter, many things. So this was brought within that. Similarly, freedom of speech. What is the freedom of speech? If you Article 1, Section 153, 154 of the IPC, all those things. Now, what is the extent of freedom? So, judicial pronouncement right from the 1950 onwards, if you look at that, a lot of changes are brought by the judicial pronouncement under the constitutions to make it under the perfect object for the country's administration. Now, that is where, in addition to this, but for the judiciary started 1976 or so, and then Justice Bhagwati was there. He started public interest litigation because he got a letter from a jail where people, by means of some action, they became blind and there was some action, jailers there. So that letter became public interest litigation, and that concept started from there onwards as a public interest. Today, it is a big weapon in the judicial hand, the public interest litigation. Administration reforms are coming through the judicial pronouncement, and the actions are being taken by the judicial. Active actions for Bhopal gas tragedy. These are all executive matters. If you take it, the separation of power of the executive legislative, most of the acts are coming by the Supreme Court, despite it is independent judiciary and independent executive there. But the judiciary has to take a role when there is a failure by the executive. So, judiciary cannot be now called. And my interaction with the American judges a few days back, see, system in elsewhere, if you take the American judiciary, they are appointed by the political parties. Supreme Court judges appointed by the political parties. Now there was a case which was handled by the Supreme Court judges, and he was influenced. The Supreme Court judge himself told me that he was influenced by the person who appointed the president, the former president of the United States. He appointed. The influence was there. So it is not that there is no influence in the other countries. So, and there, our country, the judiciary is so independent that a judge, once he becomes a judge, he becomes aloof. He segregates his all relations and he confines himself to his post and the family. But in other countries, particularly, there is a duck hunting case, United States duck hunting case, where the judge immediately after his working, his office, he goes with the client who had a case before him for duck hunting. Thus there was the picture or shows upside down, judge is mingled with it. Of course, they are not corrupt. I am not saying that just moving with the party. But independence is shown by the Indian judiciary. And the constitution, if you look at that, there is no part 4 in the United States Constitution. We have the social reforms. We have the best constitution and best interpretation of the constitutional provisions by the judiciary. So let us not touch those aspects which there are some unscrupulous incidents which can let down the judiciary. But by and large, Indian judiciary is the finest judiciary, and even today they are serving to the people and the needs of the country.
Sir, in tackling any issue, particularly corruption, there is always a clash between the rule of the game and the spirit of the game. So, in that case, which is the priority, sir? The spirit
I'll
is
tell
important
you,
or the law is important?
yes, rule of law is the only answer to the corruption. If the rule of law is strictly followed, there is no reason for corruption. If the man act according to the law, the right person will get the right answer, the wrong person will get the wrong answer. But if there is a failure of rule of law, I did not explain and elaborate while I was addressing. I just mentioned, can there be immunity for a criminal action, whether in or outside the house? If you look at the behavior of the elected representative, whether it is parliament, assembly or any assembly you take it, the way in which they behave, the acts they do, abuse the words they use, ordinary person, it is an offense. Can there be any immunity for such persons just because they are in the assembly, a privileged person? That is why I mentioned they are not the supermans. So, civil cause is different. If they are speaking, they have right to speak. But if they are committing a crime, there is no right to commit crime. So there is no immunity. And particularly rule of law, which is a hallmark of any democratic country. If everyone acts as per the rule, and one aspect which bothers is the discretionary power. In most of the cases, discretionary power comes. The discretion results indulges a person to choose. So the choice must be regulated. So rule of law, the norms for the discretionary exercise of power, these should be the criteria for the purpose of the eradicating corruption, apart from the action oriented against the corrupt persons.
Sir, may I please? The popular understanding is that corruption lives because it is institutionalized by the elected representatives, and new elected representatives learn this from, the bureaucracy, which is a continuous learning center for them.
Yes.
Unless it can be broken down as an institution,
Yes.
the effort or the whole discourse of this anti-corruption feels like a humbug, in popular perception, not my opinion. So what can be done, sir, to attack corruption at the institutional level and break it down, rather than reducing the discourse into how it boils down in the lower system? Thank you.
See, correctly mentioned, even Vijay Bhaskar, while speaking, he is mentioned per capita income. Suppose if the person is not getting the enough income to make his livelihood or to make himself to better living, he may indulge. But the person who is well-versed, person is affluent, person is. Now today, if you look at the volume of the corruption at the higher institutionalized, now very commonly. Now this has become order of the day. Now there are various areas where corruption, social reforms is the biggest area. Now the social reforms, little before we had this technology of information technology. Now social reforms, huge budget used to go to serve the people who are in need, particularly weaker section. Best example in our country where the corruption was high is with the Narega, the Mahatma Gandhi Rural Employment Guarantee Scheme. Now how many people, in fact I knew there are empty number of persons without any employment, without there being any person's name, they used to draw the money. Similarly, even today it is happening despite there being online. Mafias are there. If you go on talking about this institutional corruption, it is a huge one. It's a huge one because they don't, and to remove those mafia agencies, a strong, determined administration is necessary. A strong, determined government is necessary. And that has not become possible in our country. And that is why it is perpetuating. It is perpetuating and it is increasing by day. And if you look at the one government to another government, the level of the corruption is very high. And unless they get in, and there is also, I had an occasion to speak to the election commission in one of the incident. I said, code of conduct which comes particularly during the election, because that is the only period where the election commission takes action on any promises or anything. But that is only a short period. What happens is the pre-election and post-election? There is no control. I want that everything which connects with the election, induces the voters to vote, itself is a corruption. If you are inducing in a voter by a promise that I will give you something, you vote with me. But the definition of corruption is directly covered. Now is this the way? Then this is the administration. Now these are the reforms which are necessary. You cannot, there is a budget, there is a need for the government, long-term capital investment is necessary, there is short-term investment, social reform, and if you go on doing something which is akin to the financial administration, so we are accepting it. And the short-term election commission act, and beyond that they don't act, and prior to that they don't act. These are promises, these things happen. So institutional corruption needs to get rid of it, then you have to act as a voter.
Thank you, sir. Sir, there is one more question from the audience.
I have no mind to, you can ask any number of questions.
The question goes as this: what are the comments on the approval of the investigation by the CBI against government officials by the government of Karnataka?
Now, this is an issue which is already pending before the court, and particularly the CBI is concerned, because every state, ours is not like any United States. It's not in a federal court. Ours is not a federal structure and independent. States are there. Now every state has got its own investigating agency. So by and large, it is the state which exercise the power, and the state, in case if need, there is a high rank in the issue, they may invite and request the CBI. But in banking system, financial institutions of the national banks and other things, the CBI has a direct role to register a case in case if the financial irregularities of more than 5 crores is there. They can directly register a case.
So one last question. The question goes as this: what role can India play in eradication of corruption? Media. What role can media play in the eradication of corruption?
Absolutely. Now, Constitution initially recognized 3 wings: legislature, executive and judiciary, and by virtue of judicial pronouncement, the media is also, they became the part of the constitutional wing. Now, today, media is so strong because we have not empty number of, there is a competition amongst them, so that the empty number of channels have come. And the way in which they propagate any personality, any issue, it will have a direct bearing on the people and the public. And unless there is a regulation regulating the media, it is very dangerous. It is maybe private life, it may be personal life. Even before person is found guilty, they will convict. And even before the judicial pronouncement, they acquit them. So these are the areas, not only on the judicial side, but giving the picture, the way in which they depict the picture without any substance and without the material evidence. They must have the authenticated information to rely and make their statement. But today, recklessly, the statements are made on the medias, and media being watched by vast public, and it will have a direct bearing. So the control on media is necessary, though there are IPC provisions, they may not be sufficient.
Thank you, sir, for patiently answering all the questions in the question and answer session. Big round of applause for that. Moving on to the presidential address, I'd like to give a brief introduction of our. Alright. I request Professor Dr. V. Sudesh, Principal, Chairperson, and Dean, University Law College, Department of Studies in Law, to address the gathering.
Good afternoon to everybody. Thank you, Rohit. Dignitaries seated on the dais, Honorable Justice Subhash B. sir, Shri T.M. Vijay Bhaskar sir, our Vice-Chancellor, Professor Dr. Jayakara S M sir, Secretary of IIPA-KRB, Dr. Jeevan Kumar sir, Professor Madhwaraj sir, my colleague, former Chairperson and Dean Professor Dr. N. Dasharath, the coordinator of this program, Dr. Jyoti Vishwanath, colleagues of the dais, Dr. San Satish Gowda, Dr. Chandrakanti, guest faculty, dear students. Today indeed we had a very good discourse on anti-corruption, the legal system that we had, the anecdotes on corruption, incidents of corruption, the real experience of corruption. In his introductory remarks, Shri T.M. Vijay Bhaskar said, partly government is also responsible for some way promoting corruption. He was right when he emphasized there's a correlation between corruption, illiteracy, and the per capita income. The more you are illiterate, you are bound to get corrupted or make someone else corrupt. So therefore, his solution is the more we advance our per capita incomes, perhaps there may be less indulgence in corruption. He has rightly emphasized that government has made several efforts, whether it is the law on RTI, whether it is the Sakala scheme that we had, etc., etc. The digitization process, example, beautifully said, the railway tickets, we have personally encountered our age group people that we used to stand in long queues, and in cases where we have to book more than 10 or 12 tickets, we have to contact the agent. So from there to now, just on the mobile app, we can book tickets without corruption. Perhaps we may find solution in course of time with digitalization. Justice Subhash B. sir, in his keynote address, said the idea of corruption is an old one. A very bad idea, but an old one. From Kitturani Chennamma's regime to the present, we find corruption invading all aspects of our life. Sir, you have rightly emphasized that to deal with corruption, there are enough legislations. But then, to counter these legislations, probably the discretionary power that some of these authorities are given leads to failing the law itself. As we have said studied in administrative law, corruption leads to, discretion leads to corruption, absolute discretion leads to absolute corruption. So you have quoted several cases of the Supreme Court and incidents of realistic corruption in India. Thank you, sir. You understand the plight of a principal of a college. But let me assure you that today's program, right from the morning tea biscuit the flower bouquet, the journal, the afternoon lunch. All this has been provided in cooperation with the IIPA and the little contingency fund that we had at the disposal of the principal. ಎಲ್ಲವೂ ನೈತಿಕವಾಗಿ ಶುದ್ಧವಾಗಿದೆ ಅಂತ ತಮ್ಮನ್ನು ಹೇಳಕ್ ಬಯಸ್ತಾ ಇದ್ದೀನಿ ಸರ್. Yes, sir. If we do not cure this evil of corruption, you rightly said it is more dangerous than terrorism. An Ajmal Kasab could be hanged. But a person who indulges in corruption, he passes on the disease to someone else. That's the danger of living with corruption. Dr. Dasharath sir also mentioned several incidents of corruption and righteous living. He very rightly said that children have to be trained, children have to be sensitized on not indulging corruption. Children must question their parents. Honorable Vice-Chancellor sir, you have rightly illustrated how you actually worked against corruption by quoting the example of purchase of laptops. Sir, we expect in your regime, in this university, much more transparency could be brought about in various aspects of administration which we together are fighting, whether it is admission process of students, whether it is issue of transfer certificate or marks cards. I genuinely feel students must not be made to run around pillar and post just to get a name corrected. These are small things but matter a lot for young students who are sitting here. They must not be, they come here to learn. They must not experience the pain of standing near some clerk or someone waiting and he says, Nale banni, itto banni, atto banni. They're small things, sir, but I use this platform to tell you that these are small issues, forget about laptops, but these small issues of file movement will instill a sense of confidence that the Bangalore University, having got a NAC A++ grade, will live up to its expectation of being a corrupt-free administration university. Sir, I expect a lot and we will cooperate as principal, as dean. All of us will cooperate. Yes, corruption is an old idea, bad idea. But we are not short of leaders who have fought this anti-corruption. From the story of Satya Harishchandra, who without taking the fee did not allow the body of his own child to be burned. From Satya Harishchandra to Mahatma Gandhi, we have great pillars, inspirations to fight corruption. From Buddha to Basavanna, Buddha who taught us a righteous way of living. Buddha probably said very rightly that you must not get attached to things in life. Attachment to materialistic things, attachment for personal growth probably is one reason which indulges in getting corrupted. Basavanna very rightly said, this is in Kannada and English, I'll read this. I'll end this presentation, my presidential remark by reading this. ಕಳಬೇಡ ಕೊಲಬೇಡ ಹುಸಿಯ ನುಡಿಯಲು ಬೇಡ ಮುನಿಯಬೇಡ ಅನ್ಯರಿಗೆ ಅಸಹ್ಯ ಪಡಬೇಡ ತನ್ನ ಬಣ್ಣಿಸಬೇಡ ಇತರ ಹಳಿಯಬೇಡ ಇದೇ ಅಂತರಂಗ ಶುದ್ಧಿ ಇದೇ ಬಹಿರಂಗ ಶುದ್ಧಿ ಇದೇ ನಮ್ಮ ಕೂಡಲ ಸಂಗಮ ದೇವರ ಪರಿ. Do not steal, do not kill, do not lie, do not be angry, do not be scornful of others, do not glorify yourselves, do not insult others. These are the means to inward purity, these are the means to outward purity, these are the means to please Kudala Sangama Deva. What a beautiful vachana. ನಾವು ದೇವರು ಮತ್ತೆ ನಮ್ಮ ಲೀಡರ್ಸ್ನ ಆರಾಧಿಸ್ತೀವಿ, ಅವ್ರ ಫೋಟೋ ತಗಲಾಕ್ತೀವಿ ದೇವಸ್ಥಾನ, ನಮ್ಮ ಮನೆಗಳಲ್ಲಿ, ನಮ್ಮ ಆಫೀಸರು. ಬಟ್ ಅವರು ಕೊಟ್ಟಿರೋ ಸಿದ್ಧಾಂತವನ್ನ ಕಾಲಭಾಗ ಅದು ನಮ್ಮ ದಿನನಿತ್ಯ ನಾವು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದ್ರೆ ಐ ಥಿಂಕ್ ವಿ ಹ್ಯಾವ್ ಎ ಸೊಲ್ಯೂಷನ್ ಟು ಫೈಟ್ ಅಗೇನ್ಸ್ಟ್ ದಿಸ್ ಸ್ಕಾನ್ ಕಾಲ್ಡ್ ಕರಪ್ಷನ್. ವಿತ್ ದೀಸ್ ಫ್ಯೂ ವರ್ಡ್ಸ್ ಐ ಥ್ಯಾಂಕ್ all the guests who are seated on the dais for taking time off, especially the IIPA which made it possible that we have a cooperative program like this. Thanks to Dr. Jyoti Vishwanath who coordinated. Thanks sir for sharing, Justice Subhash sir, for sharing your experience as a Lokayuktha, now as an NGT member, earlier as a judge of the Karnataka High Court, for giving right answers and right directions to fight corruption. Thank you so much. Thank you.
Thank you, sir, for such an intricate, enlightening and warm address to the gathering. Now I request Dr. Jeevan Kumar, sir, Secretary of IIPA-KRB, to render the formal vote of thanks.
Thank you, Rohit. In a sense, Dr. Sudesh has already given the vote of thanks, but from our side, as the collaborating institution, it's my duty also to propose a vote of thanks to all of you. This program, incidentally, between the Karnataka Regional Branch and the of the IIPA and University Law College is part of a series of events that we have done and continue to do under Professor V. Sudesh's leadership. We have a memorandum of understanding with University Law College, and under that some of you may recall that we've already come before you with our ideas which have been very ably implemented by earlier Professor Suresh Nagauder and now under Professor V. Sudesh. This initiative, in fact, came from the University Law College because the Vigilance Week had been initiated by the government, and law colleges were instructed to hold programs to discuss major issues pertaining to anti-corruption, the legal regime, the issues, and so on and so forth. So when we got in touch with Dr. Suresh Nagauder and Jyoti Vishwanath, the response was very encouraging, and the outcome is there before all of you. I stand before you just to flag and to record our appreciation of all those who have played such an important role in stimulating your minds and in taking away, at the end of this program, a lot of thoughts on how we are able to, or how we intend to deal with this scourge called corruption. At the outset, Honorable Justice Subhash Adi sir, thank you very much. As Mr. Vijay Bhaskar said, the response from Justice Subhash Adi was instantaneous. We want to have a program. We're looking at you to initiate the debate, to give the keynote address, and Justice Subhash Adi was so willing to come and share his thought with you. Thank you very much, sir. To our chairperson, Mr. Vijay Bhaskar, he has also at the beginning indicated a kind of correlation between certain factors that play an important role, but most importantly spoke about recommendations made by the Second Administrative Reforms Commission to deal specifically with corruption. If I may flag one important recommendation that he has made, if government transactions, all of them can be what did he say, cashless, contactless, and paperless. We have already seen the effect of these things in many activities, in many many of the work that we intend to do with the government. And if this becomes more and more institutionalized, I think this not being able to go, not going before an officer and standing before him and cringing before him or her, I think is going to make a huge difference. Thank you very much for observations, Mr. Vijay Bhaskar sir. The Honorable Vice-Chancellor, Dr. S M Jayakara, who I think flagged three very important points that we all need to reflect on: the role of education in curbing corruption, the role of young people in curbing corruption, particularly the role of young law students like you. We look to you for more and more ideas in how this scourge can be eradicated, may not be eradicated, can be controlled, if not eradicated. Professor Dasharath speaks with a lot of gusto. He carries that energy with him whenever he speaks. It's a pleasure to listen to him all the time. And he said he's going to look at corruption from a socio-legal perspective, and it was a pleasure to listen to you, Professor Dasharath. Thank you very much. Dr. V. Sudesh, Principal, Dean, and the person with whom we are going to interact in future also, summarize, I think, the major arguments that came before all of us this morning and partly this afternoon. Thank you, Dr. Sudesh, very much. What I appreciate is the fact that he ended with Basavanna's philosophy, his tenets. If I may add or supplement to what he said, I think it was Basavanna who said, government work is God's work. So there's a lot to learn from our own. Namma Baswanninda eshtu kaliyudiದೆ ನೋಡಿ ಅದೆಲ್ಲ ನಾವು ಸರ್ಕಾರದಲ್ಲಿರೋರು ಜೊತೆಗೆ ಸೇರಿ ಮಾಡಿದ್ರೆ I think we are going to live in better times. To my fellow program coordinator, Dr. Jyoti Vishwanath, thank you very much for being with us, for helping us, supporting us. To the colleagues of the University Law College, Professor Satish Gowda, Professor Chandrakanti, guest faculty, and to all of you, the audience, you have been very attentive. You have raised very important issues for discussion. You have provoked many of us to think afresh on the issues that continue to plague us. Thank you very much. And as a small token of appreciation, there's a working lunch arranged for you at the end of this program. I will be failing my duty if I don't thank Rohit Sharma, the young, energetic person who managed the entire proceedings with crisp efficiency. Thank you very much, Rohit. We look forward to working with you in future. Thank you all very much, and please stay behind for lunch.
Before ending, I personally, Rohit Sharma GA, was honored to serve as the Master of Ceremony for this event. I thank my fellow colleagues from the students of first year, the fourth year and fifth year for helping me coordinate this event and making this event a successful one. Now, considering the gravity of the event we have, let us end this event and program by reciting our national anthem. Please rise. Jana Gana Mana Adhinayaka Jaya Jana Gana Adhinayaka Jaya He Bharata Bhagya Vidhata Punjab Sindhu Gujarat Maratha Dravida Uttara Ganga Indra Himachala Yamuna Ganga Uchala Jaladhikaranga Everyone, you can please proceed outside and you have a working lunch arranged for you.